Good evening, folks. Good evening and welcome. Good evening. I'm going to call this meeting to order at 5:35 p.m. Thank you, everyone, for attending. We appreciate all of you for participating in your local government. I also wanted to thank our Planning Commission for the work and their time spent so far. And thank you to our staff for literally hundreds of hours to get us where we are. And without further ado, Wednesday, October 22nd, 2025 at 5:30 p.m. is the time set for the public hearing in the matter of consideration of the appeal by Republic Services applicant/appellant of the denial by the Benton County Planning Commission of its application for a conditional use permit to expand an existing landfill. The Benton County case number is LU-24-027. The October 15th, 2025 staff report lists and sets out each of the applicable criteria, which are found in the Benton County Code. All testimony, arguments, and evidence received during this public hearing must be directed toward the approved criteria or to such other rule, law, regulation, or policy that you believe to apply to this case. The applicant/appellant has the burden of proving by a preponderance of the evidence that all of the relevant approval criteria have been met. As provided in Benton County Code 51.835, the board shall consider the record of the Planning Commission's decision, as well as any new evidence or testimony that is submitted into the record at or prior to this hearing. As time allows, any person may appear at this hearing and be heard. The entire record before the Benton County Planning Commission has been placed before the board by providing the entire record on the county's webpage at https://www.bentoncountyor.gov/LU-24-027-proposed-Butte-landfill-expansion/. It is part of the record for this hearing. The hearing procedure will be as follows. 1, the staff planners will present the staff report. 2, the applicant/appellant will then present their case. 3, testimony from representatives of governmental bodies. 4, testimony from those in favor of the appeal. 5, testimony from persons opposed to the appeal. And 6, rebuttal by the applicant/appellants. The applicant/appellant will be given up to 60 minutes to make their presentation. Governmental representatives will each be given 5 minutes to testify. Individuals in favor or opposed to the application will each be allowed 2 minutes for testimony. The applicant will also have up to 30 minutes for rebuttal. Please try to avoid repetition. If someone else has already expressed the same thoughts, it is perfectly acceptable to state that you agree with the statements of a previous speaker. If you have documents, maps, or letters that you wish to have considered by this body, they must formally be placed into the record of this proceeding. To do that either before or after you speak, please leave the material with Meg Rehorn, who will make sure your evidence is properly taken care of. And where is Meg? Where can people find Meg? Out in the lobby? Out in the lobby if you have documents to submit. Thank you. Thank you. To the left of the front door. Please be respectful and courteous of all those who are present. Commenting during the presentation of evidence or testimony or interrupting a speaker or a commissioner is not respectful or courteous. The chair reserves the right to remove anyone who does not abide by this direction or who engages in discourteous or disruptive behavior. A request for continuance or to hold the record open is a discretionary decision of the chair to allow the parties a reasonable opportunity to respond to additional documents or evidence provided by any party at this hearing. If the request is not granted in accordance with ORS 197.7974B, the public testimony portion of the hearing will be closed and the record will be closed. This body will continue the hearing to November 4th, 2025 at 1 p.m., at which time it will deliberate and make a decision on the appeal. And just to clarify, we will be continuing to tomorrow night as well. Finally, each commissioner has placed a record of ex parte contacts received by them into the record. I will now ask the board if any commissioner needs to declare any bias, conflict of interest, or additional ex parte contacts. First, does any commissioner have any bias to share? No. Does any commissioner have a conflict of interest? No. Does any commissioner have additional ex parte contacts not included in the written record? Commissioner Shepard.
Thank you, Commissioner. Thank you, Commissioner Wise. As you stated, Commissioner Wise, my written list of ex parte contacts is in the record on the county website. That record goes through October 14th. I've had 1, 2, 3, 4, 5, 6, 7, 8, 9 additional ex parte contacts since then. On October 16th, the Benton County Democrats, of which I am the chair, held their monthly meeting. Representatives from both Benton Clean and Strong and Valley Neighbors for Environmental Quality and Safety, VNEX, were given an opportunity to share their perspectives on LU-24-027. This discussion was organized by the Executive Committee of the Benton County Democrats at meetings where I had recused myself and in communications that I was not included in. Before this section of the meeting, I handed over control of the meeting to the first vice chair of the Benton County Democrats and left the area. Also on October 16th, members of the Benton County Democrats spoke to me and said the meeting that I just described was tense. These members described grumblings by opponents to the expansion during Benton Clean and Strong's presentation. They also described Benton Clean and Strong's presentation as, quote, rude and dismissive. At my express direction, they did not share any additional information with me or the content of those presentations. October 17th through 19th, I spent the weekend at a conference where individuals occasionally spoke to me about the topic of LU-24-027. Unless I specifically mention it, no one expressed any opinion to me or provided any testimony, data, or other information that would rise to the level of an ex parte contact. On October 18th, Saturday, I spoke with former Albany Mayor Sharon Canopa, who criticized her public services but expressed support for a small expansion to keep the landfill open. On October 18th, I spoke with Senator Sarah Gelser-Bluen, who said that her perspective on the landfill expansion was submitted into the written record. On October 19th, I received 2 emails to my county email account from Doug Pollock opposed to LU-24-027. On October 20th, I received an email from Angelica Recugler opposed to LU-24-027. On October 21st, while at an event, a constituent stated their general opposition to the proposed expansion. I can and still will make a fair and impartial decision.
Thank you. Commissioner Malone.
I don't have any additional names to submit.
Thank you. I do not have any additional ex parte contacts either, but I will share that I have received numerous emails, probably the same ones that you have. I have not opened them or looked at them. All right, the public hearing for LU-24-027 is now open. We will now commence with presentation of the staff report.
Thank you, Chair. Good evening. Chair and Commissioners, applicant, and this vast public. I want to also thank you for the opportunity to present this evening. And I want to begin by expressing our appreciation to the board for your commitment to a thoughtful decision-making process. I also want to thank planning and numerous support staff here this evening for their diligent work in preparing materials and guiding this process, and to acknowledge the many residents and stakeholders who have engaged often passionately and thoughtfully. Land use decisions are rarely easy, especially when they touch on values that we hold deeply. Tonight's hearing involves perspectives that may differ sharply. Staff approach to this conversation is with objectivity, humility, and respect. And I trust that this process will find common ground through our shared commitment to public good. So thank you. So the nature of this request is a conditional use permit to expand the Coffin Butte Landfill. Republic Services is proposing to expand the existing landfill operation south of Coffin Butte Road, construction of an 1,800 square foot employee building with off-street parking, modify an access road and relocate leachate activities, portions of a perimeter landfill road, an outbound scale, and construct a shop and maintenance area. The applicant is also proposing to modify access to the north of Coffin, proposing to modify access to the north side of Coffin Butte Road as well. And by the way, I begin speaking quickly, so please, if I have a problem with cadence, please let me know. I appreciate that. So in concert with the recommendation from the Benton County Talks Trash, the county joined a third-party land use and engineering professionals. And so I'd like to give them an opportunity to introduce themselves this evening. First of all, we do have Public Works here. Gordon, would you like to introduce yourself?
I'm Gordon Kurtz, an associate engineer with Benton County Public Works.
And I'll introduce myself. Petra Sheets, I am the planning director here at Benton County.
Hello, I'm Jesse Winterroad with Winterbrook Planning.
Hi, I'm Larissa Gladding with Winterbrook Planning.
And we have some folks online this evening.
Hi, I'm Ellery Howard with Malfoster Alonji, and there are a number of other folks here from MFA as well that I'll let them introduce themselves.
I'm Chad Darby with Malfoster Alonji, a principal air quality consultant, and was involved in reviewing the odor sections.
My name is Bill Beatty. I'm with Malfoster and Alonji, and I was involved with evaluating the noise evaluation reports.
And I am Courtney Savoy with Malfoster Alonji. I am a senior hydrogeologist, and I reviewed some of the groundwater materials.
And I am Eric Bockham, principal engineer with Malfoster Alonji, and reviewing the overall package.
I think that's everyone. Thank you. I just wanted to take a moment to say that we also have a standard process when we go through applications of these to put out to our agency partners for recognition. And so I will just simply, for the record, read out the comments of the respondents and those that did not respond. The Oregon Department of Geology and Mineral Industries, the Oregon Department of Fish and Wildlife, Benton County Environmental and Natural Resources Advisory Committee, the Adair Rural Fire Protection District, Oregon Department of Transportation all responded with comments that are in the record. And the folks that did not respond included Adair Village, Army Corps of Engineers, City of Corvallis, Oregon Department of Environmental Quality, Oregon Department of Land Conservation and Development, and the Oregon Department of State Lands. We'll be moving on to the proposal description. And I thought I would give discretion to the chair for reading the long narrative associated with the project description, or we can move on with a brief description of the illustration.
Do the commissioners have a opinion one way or the other, preference? More information or the slimmed down version? Or a slimmed down version? Commissioner Shepherd.
I think all the information's in the record, and for the sake of time tonight, I think that a slimmed down version this evening would be preferable.
Okay. That has saved us 5 minutes. Thank you.
Thank you.
I will point
Yes.
out that the illustration that you see on the screen, though, the red line does indicate the development area, and the illustration to the left is also an illustration that includes the zoning districts. The next thing we wanted to talk about were some of the distinct words or verbiage associated with the parameters of this evening's review. This land use decision is quasi judicial, so that means it's discretionary function similar to a jury and a continued process on appeal from the Planning Commission's decision last summer. The expansion of the existing landfill in the landfill site zone requires a conditional use approval, as does the proposed development, like the employee building, the shop, and things of that nature that are in the forest conservation zone. The burden of proof is on the applicant, Republic Services. They need to provide sufficient evidence that the proposal meets the current code criteria. The staff's role is to analyze the burden of proof and to develop findings or staff recommendations for your consideration based on factual questions specific to the proposal. Those are the respective roles. De novo has become a point of conversation and perhaps confusion in the last couple months as we've set up this process. In Benton County, these types of appeals have de novo hearings. De novo hearing is held without being bound by the findings or conclusions of the lower decision-making body. So new evidence is allowed. Parties may submit new testimony, documents, and other evidence that wasn't presented in the original hearing. The board makes an independent judgment. The reviewing body makes its own findings and conclusions rather than simply deferring to the prior decision. De novo is not a limited appeal. It's not just a review of the record or a check for procedural errors or legal mistakes. The decision is not bound by prior findings. The reviewing body does not simply affirm or reverse their earlier decision based on the existing record. And I wanted to check in with you to see if there were any questions, and our attorney can answer them.
No questions.
Thank you. Our code criteria. Our code criteria is rather ambiguous in our code. And so I wanted to spend a little bit time describing to you some of the interpretations that came out of the Benton County Talks Trash. And so there's clarity about what's before you. So the first criteria, the decision is to, or criterion is the decision is to approve a conditional use permit shall be based on the finding that, one, the proposed use does not seriously interfere with uses on adjacent property, with the character of the area, or with the purpose of the zone. Staff adopted the BCTT process definition for seriously interfere as if the proposed use makes it difficult to continue uses on the adjacent property, would it create a significant disruption to the character of the area, and or would it conflict in a substantive way with the proposed zone? And the code does not define adjacent, nor did the BCCT contemplate that. The applicant, however, did define adjacent on, I believe, page 19 of their burden of proof document as they started with a base site that includes all the tax lots on which the existing landfill operations and the accessory uses are located, plus all the tax lots constituting the development site on which the project will be located, or, quote, the landfill boundary. Second, the applicant then identified properties abutting the landfill boundary, quote, the adjacent properties, and the properties abutting the adjacent properties. So there's some discretion in interpretation there that may be part of the deliberations. Third, the character of the area. The applicant describes this as a 90 square mile rural and urban development resource land, varying with topography and natural habitats, and, quote, occasional odors, sounds, noises, and trips from the existing landfill operation and surrounding resource extraction uses. Two, the proposed use does not impose on an undue burden on any public improvements, facilities, utilities, or services available to the area. Staff used the BCCT interpretation interpretation of undue burden, which is on page 61 of the staff report. And that was a unanimous interpretation of no particular controversy. So I will not read that. And if there's any questions, we're happy to revisit that. Finally, the proposed use does not seriously interfere with uses on adjacent property, with the character of the area, or with the proposed use of the zone. And there has been a waste disposal site there since 1948, and it became allowed use in 1983, and so that's for you to decide. Finally, we did learn some operational lessons from the Planning Commission process and is trying to improve with the information that we provided that body. And one of those areas was to clarify what the limitations of your review are. And so we researched into the Oregon land use law and brought out some of the highlights of that. And so I want to spend some time to help clarify some of those areas that you will want to avoid in your consideration. One, conditional use permit decisions must be grounded in the applicable criteria. We've talked about that a lot. It can't be more than that and it can't be less than that. And so here's a short list of some of those things and the justifications for that from LUBA case law. May not consider the future or speculative adjacent uses. So conditional use permit decisions must be based on current zoning and land use patterns, not hypothetical or future changes. There's several case examples about this, and the Oregon Supreme Court regularly has upheld saying that speculative future uses of adjacent land use cannot justify the denial of a conditional use permit. Second, property values or tax revenue impacts. This is excluded because the Oregon courts have ruled that potential impacts on neighboring property values or tax base are not valid approval criteria unless explicitly stated in the code. LUBA precedent has consistently rejected arguments that the conditional use permit should be denied due to perceived negative effects on property values. 3, franchise or the hauler's agreement in this case. Outside contracts content is off limits. 4, public opposition or popularity. Public sentiment alone is not a valid basis for denial unless it is tied to specific applicable approval criteria. The legal principle is that decisions must be based on findings supported by substantial evidence in the record, not on the number of opponents at a hearing or proponents. Next one is moral or religious objections. Land use decisions must be secular and objective. Courts have rejected conditional use denials based on moral disapproval of use, like adult businesses, marijuana, religious institutions. First Amendment and equal protection are those components. Next, generalized traffic concerns without evidence. Traffic impacts must be supported by expert testimony or studies. Anecdotal concerns or assumptions are not sufficient. LUBA's guidance is that traffic must be evaluated against specific standards in the transportation element of the comprehensive plan or code. Non-applicable plan policies or aspirational goals. Only mandatory approval criteria, general policy statements or goals in the comprehensive plan can be used to deny a just a second. Conditional use permit. Unless codified as criteria, LUBA has ruled that aspirational language like encourage compact development is not enforceable unless it's adopted as an actual standard. Second to last, alternative sites or preferred locations. The applicant is entitled to a decision on the proposed site. Decision makers cannot deny a conditional use permit because they believe that another site would be better. The legal reasoning is that the focus must remain on whether the proposed use meets the criteria at that proposed location. And finally, economic competition or market saturation. Land use decisions cannot be used to protect existing businesses from competition. So denying a conditional use permit for a new grocery store just because it might harm an existing one is not a valid land use concern. I'd like to pause here and ask if you have any questions about these.
Questions for clarification? No.
Thank you.
Oh, sorry, did you have one? No, no.
Okay, thank you very much. This ends my portion of the presentation, and Jesse Winterbold is going to move on to our key findings.
Hello, does this work? Yes. Okay, great. So thank you, Petra. And we will move on to the majority of the staff report. The issues overview that we're starting with is also reflected starting on page 7 of the staff report. And I am going to sort of continue the theme that Petra started, and starting off with the DEQ EPA regulations and air and water quality. As part of the established regulatory framework, DEQ and EPA are the sole authorities for regulating, monitoring, and enforcing state and federal environmental standards related to air and water quality. The BCC, the Benton County Code, does not include any provisions regulating air quality or water quality and water quantity. Staff recommends that the board's review be focused on evaluating landfill expansion impacts that are within the county's regulatory authority under the BCC and are not under the explicit regulatory and permitting authority of state and federal agencies. Staff does recommend a condition of approval requiring all state and federal permits prior to beginning any ground disturbing activities. Second, there was a lot of conversation on the number of conditions of approval and whether they were enforceable in the Planning Commission decision of denial. And I think I will state that conditions of approval are very normal for conditional use applications, and large applications often have a large number of conditions. So we would recommend that you focus on the content of those conditions rather than the quantity of them. Also, in response to concerns about the lack of county funding for enforcing future conditions, which was, I would say, fairly reasonable, relating to the landfill, there is a condition originally proposed by the applicant that we, as staff, I feel strengthened considerably to, well, fund the county for code enforcement related to the landfill, monitoring, enforcing, and reviewing the conditions, which we would recommend adopting as a condition should you wish to approve this. We have spent a good amount of time and effort drafting the conditions. We've worked with our third-party engineering consultants as well. And yeah, we encourage a discussion of those conditions as needed throughout this.
Perhaps getting a little closer to the microphone.
All right, is this good?
Is that better?
Okay.
Okay, thank you.
All right. Sorry, guys. I'm I think pretty close to a speaker, so it's loud for me, but hopefully everybody can hear this. Context of the existing use versus the proposed expansion. This is a pretty interesting dynamic, and the way we looked at this is we're reviewing an expansion of the existing use. It doesn't mean the existing use isn't there. The existing use is there. There's a landfill. But a lot of the concerns raised by the public were related to that existing landfill and not as focused on the actual application in front of us, which is an expansion. I think a good example of this is we have testimony from an adjacent property owner to the south who said the landfill is rising above the Tampico ridgeline. And now this person can see and hear the activities on the existing landfill. That existing landfill is approved, and there's not much we can do about that in this application. The proposed expansion, however, is limited to below the ridgeline. So the impacts, visual, noise, like all of those things are different than the existing landfill. And so when we look at that, that situation, we say, well, we have to look at what they're proposing and evaluate that. The existing landfill provides some context. It provides sort of a baseline of what's going on there, but the proposal is what's in front of us, not the existing landfill that's already been approved. Construction impacts, this sort of builds on some of what the planning director was talking about. We do have a recent LUBA decision that said that the evaluation of the conditional use should be based on the use itself and not on construction of the use. And so we would recommend that you look at the impacts of the proposed use rather than trying to figure out construction related impacts in relation to it. And I think that would be both appropriate and legally defensible. Then we have weighing of evidence. And this is a subject that came up during the deliberations for the Planning Commission. In order to create findings that reflect your decision, whether that's approval or denial, we have a lot of evidence for almost everything that people are talking about. We have applicants' evidence, we have a lot of testimony from the public that's evidence, we have third-party engineers weighing in. So if you are making a decision on whatever impacts, whatever side of the decision you come down on, letting us know what evidence that you relied on for your decision will allow us to provide findings in support of that much more easily. So if you weighed some evidence over other evidence because you got 15 pieces of evidence, what was more compelling to you? And if you let us know, then we can use that in the findings and be effective. The staff report that we did for this process was mainly focused on the conditional use criteria. It's the most controversial, the most evidence, the most discussion of impacts. And so this staff report is mainly focused on Chapter 53, which has the conditional use impacts. We do cover the rest of the applicable relevant code chapters. And one thing that I'd like to mention with this, and this is for everybody in the room, we did have links that we put into the staff report this time that link to all the evidence testimony that we used in the staff report, so that if you're looking at it online, you can click and it'll take you to the evidence that the staff report is referencing. So please take advantage of that. As part of the conditional use, we looked at a lot of different impacts: noise, odor, traffic, visual, litter, fire risk, wildlife, air quality, water quality, and county monitoring enforcement. As part of this new staff report, part of the last staff report too. And we integrated the Planning Commission findings and linked to those. And we integrated new applicant information as well as testimony that came through recently that we're able to bring into the staff report. So all of those are part of the impact discussion, as well as recommended conditions of approval. So our overall recommendation here is we're recommending approval with conditions. And we have three types of conditions here to make it a little bit easier to understand. It's not just a whole mass of conditions. There are phase one pre-construction conditions, which is before they turn any dirt, before they do any ground disturbance, they have to do, well, we're recommending that they have to do quite a few things, such as get their Oregon DEQ permits in line, Dogami, every applicable permit that they need to do this landfill, they need to show the county prior to that. Part of the phase one pre-construction conditions that we're recommending is the condition of monitoring, of funding the county to monitor and review and make sure that what the county's getting is consistent with, should the county approve this, the application materials and the conditions of approval. And that condition, which starts in phase one, applies to phase one and lasts 4 years beyond the closing of the landfill. So it's funding to look at and review conditions, monitor for the entire lifespan of this project. Phase two conditions are basically making sure that they're doing what they're supposed to do during the construction period. And this is making sure that they're staying away from protected habitat, making sure that they're monitoring their sentry wells, quite a few conditions that are just making sure they are setting this up right before, and all of those conditions, all of phase two need to be complete before they can start commercial operations, which then leads to the performance requirements. And these are things like their fire mitigation plan, their noise mitigation requirements that we can talk a little bit about, odor. So all of the impacts and all of the things we're talking about in terms of making sure those impacts don't rise to the level of serious interference for this expansion, those are covered in the ongoing performance requirements that we're proposing. So we get into key findings in relation to the conditional use application. As planning director mentioned, the main criterion here is seriously interfere with uses on adjacent property, character of the area, or purpose of the zone. And we looked at every one of these impacts under that light. So we can go into the first major item, and I would say all or nearly all of these, we had, I believe all of them that we're going to be talking about, we had either MFA or Keller Engineering as third-party engineers look at the applicant's submissions and see, were they technically adequate? Did they, are they reasonable? Do they rise to the level of potentially reducing impacts to below serious interference? And if you do have questions related to any of these items, noise, odor, the experts are online to provide feedback on details. And I'd say we did rely on that feedback quite a bit for our review. So for noise, we are recommending two conditions, well, two types of conditions. One in pre-commercial operation to replace, before they can get started, they need to replace all their backup, tonal backup alarms on on-site equipment. And they need to establish, again, a field measurement of noise and create a reduction of 10 decibels from existing conditions, and using the same methodology for noise measurement. And then during ongoing performance requirements, we're looking at establishing and enforcing actual hours of operation that are 5 to commercial customers other customers at 8 a.m. and close to both commercial and all customers at 5 p.m. So actual hours that the county can review and enforce during the operation. We also have ongoing noise evaluation and submissions to the county during this time using the same methodology that their original noise study did to ensure that what we're actually seeing or hearing in this case is consistent with what was modeled. And we also have the maximum elevation condition on this landfill at 450 feet of fill material that will reduce the potential for going up above the ridge lines and expanding those impacts. Odor was a very, very difficult impact to really get your head around as a planner and reviewing what is an impact. For some people, they can smell much better than other people. And so what we asked is there be some sort of model to say, well, how could, what does this actually, how do you look at odor here and how do you evaluate odor? And so we asked MFA to evaluate the applicant's odor model. Our original staff report in April recommended denial on this particular topic because their odor information was not good enough, not supportable by the evidence. And so we had MFA spend a good amount of time trying to make sure that the applicant's odor model was consistent with best practices for odor science, odor engineering. And what the odor model shows for this expansion is on a typical day, you would have a noticeable odor below 4, above 1 at the property boundary. And that is something that we determine is not rising to a level of serious interference. So that is the odor model that we are working with. And we also have a number of specific conditions related to odor that I think will be a lot more effective than the current situation that we have right now with the landfill. And that's establishing odor survey points, daily odor surveys, and also limiting the working face, daily cover, interim cover, a lot of operational conditions. How are they managing this face? And then a third-party review of their odor evaluations and their boundary patrols. And as long as, if they are inconsistent, the third party is, so odor, as you know, if you're in a place that has a lot of odor, you become sort of attuned to the odor and you don't smell it as much. And so bringing somebody in from outside to check and see, are they measuring the odor themselves accurately? That's pretty important. And that's a condition. And if, and it's, we wrote it to be the first 48 months of landfill operation to have these third party come in and check. But also if they don't agree, the third party doesn't agree, that condition continues indefinitely. So that the third party has to come in and confirm. They have to change their approach if the third party doesn't agree, and then continue to pay for that third party to come in and report to the county that whether or not they're actually smelling things right at the border, which I think is a lot more than you have right now, and I think would help resolve a lot of the current disagreements about odor between the landfill and the neighbors. Next, we have transportation. We did have Keller Engineering look at the applicant's transportation. The applicant added a piece on including construction traffic. They found that they being the applicant and the review found that there was no evidence of impact on the public facilities beyond their capacity or even close to their capacity. And so we have some conditions that they build the public facilities consistent with the plans and public work standards and ongoing performance requirements requiring that they do basically what they said they would do in terms of their traffic assumptions. And yeah, so that was a fairly straightforward piece here. We also have water quality, and this is an interesting one because you have, as I said before, DEQ regulating water quality and sort of a limited ability of the county to get into chemical evaluation of quality. And but we did see a concern regarding groundwater and wells and water quantity. And the applicant provided additional information regarding water quantity. And we had MFA bring their hydrogeologist in and take a look at that. And what we found here was that there were some conditions that were merited to make sure that the activities don't disturb groundwater supply for adjacent properties. And this is pretty specific to digging a big hole in the ground and that being sort of a foundation of the proposed landfill. So these conditions are, we have a 2-year establishment of a baseline of groundwater conditions, sinking in borings and figuring out over 2 years where the level of the aquifer is, the fraction of salt, and the water level. And also, while they're doing that, establish baselines for a variety of chemicals in the water supply. What is it right now? And in order to even begin, this is phase 1. Before they turn any dirt, they need to spend 2 years monitoring the groundwater level and quality in order to have that documented and turn that into the county. So we also need Dogami permits prior to any sort of ground disturbance. That groundwater monitoring continues through all of the commercial operation, through the pre-commercial operation, I'd say, through construction, to make sure that construction isn't changing the groundwater supply or quality. But by establishing the baseline, we actually have a good basis for that evaluation. And then during the ongoing commercial activities, we have a number of conditions relating to how they are dealing with stormwater, groundwater, making sure they're continuing to be consistent with environmental regulations, and all of their permits are up to date. And in all these situations, if we have these conditions in, the county can pull land use approval if the applicant doesn't comply with things. You're not relying on a different agency to stop the land use, but if they don't have the permits, they can't start and they can't continue in the future. So that gives a level of protection. Visual impacts. The proposed expansion is quite a lot less exposed than the existing landfill. It's smaller, much lower, over 100 feet lower, and by limiting that height and limiting the expanse to areas that are screened by Tampico, we also have a screening requirement that is a little different than your current landfill conditions, in that it requires, if trees die, that they be replanted every year. So this is intended to establish a tree buffer and maintain that tree buffer through the life of the expansion area. We also have conditions that limit outdoor lighting to be focused inward and not outward toward neighboring properties. Then litter impacts, and this was one of the more compelling pieces of testimony where we have impacts on livestock in adjacent properties. How do you, right now, there's the existing landfill, there's trucks, there's a variety of things going on. How do we look at the expansion as a litter impact? And one of the pieces is, well, let's make sure it's at least not rising above the ridge lines. You know, that I think that'll help in just itself. But more importantly, we have much more robust litter control as part of this project. We have multiple levels of fencing. We have a requirement that all of these things are things that the county hasn't been able to really look at and enforce in the past, but now we have, we're proposing a condition that the Republic Services landfill doesn't accept loads that are even partially uncovered, to make sure that people are covering their loads on the way. And we have a condition that they have to clean up multiple adjacent roadways. And also that if they're allowed to, they will be responsible for cleaning up private property as they can. So, you know, obviously we can't require them to go onto private property, but that would be their responsibility in a proposed condition. Then fire risk. We looked at this, had MFAs, fire experts also look at this. The conditions are basically, here's the, they need to do what they said they were going to do on the fire risk plan. That is best practices for fire control. And if they are doing those things, then we feel they're responding to the concern and will not provide a serious interference on adjacent properties. One of the conditions that we discussed previously in the Planning Commission was one of the items of concern was the amount of water trucks. They had a single water truck that sometimes went off site. And now we have a condition that they have two water trucks at all times with 4,000 gallon capacity. Another item that we noticed as staff, we had a discussion from the community that said, well, we're concerned about what happens on red flag days, or there's high fire risk. And the landfill was not apparently receptive to full-time monitoring of the landfill during those days. We have a condition that will require that full-time monitoring during red flag days to respond to that concern. Air quality, again, it's difficult for the county to figure out and put into code the explicit limits on types of potential concerning pollutants. However, the state and federal regulations do actually apply to air quality concerns. And that's what we would recommend that the county require prior to beginning the ground disturbance, is they get their DEQ and air quality permits, as well as continuing through all of their operation, that they need to continue those permits and show the county that they have those permits in order to continue their use. So moving on to undue burden. It was raised quite a lot in terms of if we that's somebody else. Okay. Yeah, if we have all these conditions, even trying to monitor and enforce these conditions is an undue burden on the county. And we feel like that, we have this proposed condition that would take that burden and actually fund compliance enforcement. And so this wouldn't be a burden on the county to hire experts and monitor and send somebody out. It would be something that's actually funded to do that compliance enforcement. And in that respect, I think we have written the condition to start at, if you approve this, at the moment that this decision is final. So that it takes a lot of the burden off of the county to actually fund and deal with this. So that's where we are. And we ended up with a recommendation for approval with that 3 phases of conditions. Happy to talk about anything else. We have some proposed motions, but I think we have a lot more to talk about from the applicant and everybody else.
Thank you. Is this a good time for questions? Yes?
Yes,
Okay.
we're here for questions. Yeah.
Great. Commissioners, questions? Commissioner Malone?
Yeah, a while back, you talked about hours of operation, and maybe I missed it, but I thought I heard 8 o'clock. And that's on the staff report, that's for all other customers, that commercial tipping can start at 5 o'clock.
Right, that's correct.
Okay. And this is a more general question. Some of these conditions seem like they apply to more than just the area of expansion. Like you were just talking about the fire mitigation. Is that correct? Some of these conditions apply to the whole landfill rather than just the area of expansion.
I would say the funding condition applies on the funding for compliance officer applies on approval. And there are 3 phases of conditions. Some of these conditions will only apply during commercial operations of the expansion cell. And so the other cells would be closed at that point. And you would have the expansion cell operations that we're reviewing right now. And does that help answer the question?
Yes.
Commissioner Shepherd?
Yes, I have a few questions for staff. I'll start with the undefined term of adjacent. So on page 26 of the staff report, the applicant cites Webster's third New International Dictionary for the definition of adjacent, stating that it is, quote, not distant or far off, nearby but not touching, relatively near and having nothing of the same kind intervening, having a common border, abutting, touching, living nearby, or sitting or standing relatively close, near or close together, immediately preceding or following with nothing of the same kind intervening. So that's the definition that's in the staff report and that the applicant proposed. On that same page, there's a map that shows properties that directly abut the landfill and that the properties that directly abut those properties. So a map that's like magenta and then green, similar to that one. The applicant defines the first layer as adjacent, and then the other one is nearby. And I know our planning director mentioned this in her report. So my question comes because also on that same page, 26, it says staff concurred with the use of Webster's definition, but included adjacent for the purpose of review of all the properties the applicant identified as adjacent and nearby. So my first question is, why did staff choose to evaluate both of those as adjacent? And to a second part of that, why did staff choose to accept both of those as adjacent and only those properties as adjacent? So what was the rationale behind that?
So the rationale there was we wanted to make sure that we had all of the properties that were under discussion for the landfill activities. And we wanted to have all of the properties that were owned by the applicant. And those are not entirely the same. And so we didn't want to have our review be, okay, we are looking at the applicant's own property adjacent to their landfill activities and saying, okay, there's no impact on the applicant from the applicant's activities. And so what we wanted to make sure that we had is all of the properties that go beyond the applicant's property. And so this was, I felt, pretty good. This would make sure that we captured all of those if we brought in abutting plus abutting, because we have the landfill and then some properties beyond that are, some of them are owned by the applicant. But if you go one step beyond that, you'll definitely get properties beyond the applicant's property. There's a little bit of nuance in this as well, because you have it, you might have an applicant's property that is leased to somebody else who then might be impacted by the activities of the landfill. And so we want to make sure that those people, the impacts on them are also evaluated. And so it can't just be beyond the applicant's ownership, but sometimes within the ownership. And so it's a lot of things that we wanted to make sure we captured. And since the applicant provided this map that definitely captured all the properties beyond theirs, as well as properties within their ownership that we want to evaluate, I thought, well, this will capture the adjacent properties, as in if they had come in with a map that was just, here's our landfill, here's our properties, and here are those properties adjacent to our site, we would have said, okay, well, that's good enough. But here we have, it's beyond that in some cases, but I just wanted to make sure that we captured everything that should be captured adjacent. And and that's what led to this, to us saying, well, yeah, this is good enough for us to evaluate.
Two more questions on that. The first, I think, is for our planning director. Are you aware of usage in the Benton County Code of the word abutting? Does that word appear in any of our code in any other places? Sure. Yeah.
Hi, Commissioner Shepherd, thank you. Abutting is used in BCC 91.650, 73.140, and 85.405.
Okay, so it's a term that our code does use in certain situations. Thank you. And my second question on that is, and I'll ask this of the applicant as well. What was staff's rationale? And I think you slightly spoke to this when you said you were using their map, but of using property line, the property line touching as opposed to a distance from the landfill. So why were we looking at tax lots or property lines when we're not, instead of a mile or half mile distance or something like that?
So that's in some cases, we use a distance of a quarter mile for impacts. And often in conditional uses, we've used a distance based on impacts in a different wording where they talk about impact area and they don't talk about adjacent properties. And this code section says adjacent properties, and that is not defined. And so we said, well, adjacent, next to, nearby, that makes sense. The applicant's definition looked like it would capture everything that was adjacent and even nearby on the map. And we thought that's good enough. We didn't try to create a specific distance definition for it.
Thank you. My additional questions have to do, well, the next one has to do with our responsibility for evaluating. Actually, both of these do. So I believe that this was touched on before, but just to confirm, we cannot make our decision based on how the applicant may or may not have complied with conditions of approval for the current state of the Coffin Butte landfill. But we should take into account the application, public testimonies, applicable studies, and other items submitted into the record to establish a base when we're talking about serious interference. Is that correct?
Yes.
Okay.
You're quoting from the staff report, so is that a quote from the staff report?
I have the quote from the staff report, but yes.
So I believe you, yes.
Okay. And then the final one, I just wanted to confirm something, and this is another thing that was mentioned in the slideshow, but I just wanted to put it out there as well. It's just to confirm, is it correct that nowhere in the criteria that we have to use for evaluating this application are we allowed to take into account the annual franchise fee received by Benton County from our public services, the applicant's financial situation or their businesses, or the impact of potential rate changes on county or regional residents?
That's correct. And that is to protect a legally defensible decision.
Thank you. That's the end of my questions for staff.
I want to piggyback off of one of the questions that Commissioner Shepherd asked about the word adjacent. Is it correct that if the commissioners believe that the adjacent area or the area of impact is greater, for example, up to 1/4 mile, that is at our discretion?
So we have not, and the applicant has not evaluated that. And so if you just create a different area and say, well, this is what adjacent means, that we wouldn't have enough information to evaluate that very well in this forum, right? And so if you have taken some areas out, added some areas in, I don't know that it helps the evaluation very much, because as we look at these impacts, they're typically decrease with distance. So yeah, I think that would put a risk factor into the decision that may not need to be there. I think there should be a really good reason.
Yeah, I'll give you an example. So the odor model covers that area. If you change the area, then the odor model is no longer valid.
Thank you. That's helpful. And I did want to ask another question about the odor, and I'm trying to think of the best way to ask it. I'm trying to navigate how we would judge the potential odor impacts while not considering the current odor impacts, which are, and I'll remind the audience to please be courteous. There are current odor impacts, and so we're not allowed to consider that. How do we judge? So there's this odor study, we just have to take that as the word. Is that what? Is that correct?
I wouldn't say that you have to take it as the word.
Okay.
I'd say that's the evidence that has been presented by the applicant. And we have had our third-party odor engineers review it. And they actually spent a lot of time trying to make those assumptions consistent with odor modeling requirements. And ultimately, the odor engineers have found that this model is consistent with best practice for odor modeling. So that's what I would say. You don't have to accept anything. And if you have other evidence that you think is more compelling, then you just have to tell us about that.
And I invite you to question the odor expert that's online this evening with any questions that you have.
Right.
Okay. And then I want to ask a hypothetical question, and I want to put emphasis on the word hypothetical. The Board of Commissioners, if we choose, if we decided to approve and uphold conditions, we could change conditions, add conditions, remove conditions. Is that correct?
Yes.
Okay, thank you. Any other, Commissioner Shepherd?
I guess I have a procedural question. I have questions for the applicant about odor. And I want to be able to speak with our staff about what the applicant says about those questions. So I guess a question for the attorney, at what point would that be applicable? When could I ask those questions?
I think we would want the odor consultants to remain on the Zoom. And I think what we could do is have the applicant do their presentation, and then you could ask any follow-up questions of staff.
Okay, thank you.
Other questions? All right, we have no more questions at this time. I believe that concludes the presentation of the staff report for now. And we will now turn to the presentation by the applicant/appellant. And I again want to remind the audience to please be courteous. Laughing or talking from the audience is disruptive. And if you engage in these activities, I will have to ask you to remove yourself. Thank you.
Chair, could we take a brief recess while they switch?
Sure. How long do 5 minutes? Okay, 5 minutes. We'll come back at 6:53. If everyone in the audience could take their seats, then we will continue on. Can everyone in the audience please take their seat? Thank you very much. And we are ready to continue with the presentation by the applicant/appellant. Welcome.
Thank you, Chair Weiss, members of the commission. For the record, my name is Jeff Condit. I am special counsel for Valley Landfills, Inc. And my name and contact information is in the record. We appreciate the opportunity to appear before you today. Everybody's put in a ton of work on this, proponents and opponents. And
Could you speak a little closer to the microphone, please?
Okay.
Thank you.
Your text said, pretend I'm eating an ice cream cone, and I think he was right. So anyway, we are delighted to be here and have the opportunity to make our presentation to you. I am going to turn the mic over to Brian Roop. He is Area Vice President for Republic Services, and he will introduce the rest of the team. I just wanted to note, we four up here are going to make most of the presentation tonight, but we have all of our experts. The team that's sitting up here are going to make the presentation tonight. I feel like God here. But we do have all of our experts live in the back, including our odor experts, our sound experts, and all of the experts dealing with most of the issues tonight. So anticipating the commissioners will have questions from them, we'll invite them up and have them introduce themselves at the correct time. So I'm going to turn the mic over to Brian Roop. Brian is Area Vice President for Republic Services, and he will introduce the other two members of the team that are up here.
All right, how's this sound? Okay. All right, good. So good evening. Obviously, as Jeff said a couple times, my name is Brian Roop. I work with Republic Services. Joined here to my left is Brett Davis. He's our General Manager of our Western Oregon Business Unit, and Coffin Butte Landfill is part of that. And then on the end is Brent Lurch. He is our Area Environmental Manager, and we'll speak to some of the compliance components of our presentation. And obviously, our whole team, both consultants, expert consultants, and the rest of the local team is behind us should we have questions that we can't answer directly, okay? I'd also echo Jeff Condon's comments and sentiments and just say that we appreciate everybody's time. I think staff said it well. There is a lot that has gone into this process. And although I wouldn't necessarily categorize it as fun, I would categorize it as valuable, right? So I think you'll see some of that fruit throughout our presentation. Our hope tonight is to not restate everything that the staff report has in it and or everything that they just went through, but to then touch on some key components that we feel like probably everyone will want to talk about and highlight some of those as we walk through the presentation. Maybe as a start, and Jeff, if you could forward a slide, please. Just a quick overview, and I think staff touched on this a bit, but thinking about how this application has evolved over time, going back to a prior application, obviously the landfill expansion is 50% smaller than what it was originally proposed as. And I think there's a couple of key components. First, just visually, it is much smaller. And secondly, it preserves Coffin Butte Road, which I know was a very important aspect to the community. And so all operations, as staff mentioned, is south of Coffin Butte Road. And in fact, not only is Coffin Butte Road preserved, but we'll be improving it. In addition, that landfill, as it shrank in size, the expansion area is also staying within the landfill site zoning and not ranging outside of that. A number of things have changed. We've added, including improved vegetation along the road to help visual impact. And in addition, I think we've gone through, or the staff has gone through a number of the conditions of approval that we've kind of worked on over time. And those things aren't limited to, but some of the key ones that we went through already: noise, groundwater, odor, litter, and fire. So as we walk through this, we'll have some more comments on that. But these are some of the ways that we have listened, heard, and the application has kind of evolved over time. So with that, I'll hand it back to Jeff to kind of talk a little bit about some of the land use criteria.
Thank you, Brian. I just want to note at the beginning that we agree with the staff report and agree with all of the conditions of approval. We are not asking for any changes to the condition, and we very much appreciate staff and your independent consultant's recommendation for approval. So actually, Missy, Brian, and or not, Petra Sheets and Jesse Winterode sort of stole most of my thunder because I was going to talk about the interpretation of criteria and the application of the law. So I am going to try to, and I agreed with their representation of that, but I did want to hit a couple of points. And one of those is the interpretation of criteria. So there's a case called State v. Gaines, and it says that you look to the text, the context, and the legislative history when you're trying to interpret some criteria. And with regard to the text, obviously the language that you use in the code is the key component. The courts have adopted something called the plain ordinary meaning rule, which is if a provision is not a term of art or otherwise defined in the code, you turn to the dictionary actually to construe that. And the dictionary the courts turn to is the one we use, Webster's New International Dictionary. That's the one they always referred to. In fact, former Justice Jack Landau wrote a humorous law review article where he called Webster's the eighth justice because the 7 human justices on the Oregon Supreme Court refer to it so much in their decisions. So turning to that as an authority has a legal basis and is the reason why we defined it that way. And the other thing you look at is context. So context includes other provisions in the same statutory scheme. It includes your past decisions, applying that standard before. And so part of our argument was based on that. So in the code, you'll notice that they have a requirement to look at adjacent properties and then the character of the area. So if you look at that in context, the reasonable interpretation is that the adjacent properties were basically properties that are next door to the use that's being proposed. And the area, it looks at the impact on the larger sort of landscape surrounding the use. And with regard specifically to the determination of adjacent properties, when we initially submitted our application to the county, we looked only at the area around the expansion, and we looked at directly abutting properties. And staff sent us back. They said, that's not good enough. We want you to go out to the boundary of the landfill use and then look at properties beyond that and abutting properties beyond that. So that was what resulted in the map that's before you. We agree with staff that that is a reasonable interpretation of that law, and that gets at impacts to adjacent properties within the meaning of the code. As somebody responded to Commissioner Weiss, if you decide, well, we want to go out a quarter mile, then that would require us to go back to the drawing board on everything that is related to those adjacent properties. So it would have a significant impact. And I wanted to talk a little bit about the Planning Commission, the deference that's given to the governing body's interpretation. Because you do have deference, but that deference has limits. The Board of Commissioners, as the governing body of the county, is granted some deference. And what that deference is if there are 2 plausible definitions of interpretations of an ambiguous code provision, the push goes to the county. The court, reviewing court or LUBA will defer to the county's interpretation on that. But it's got to be plausible. And plausibility is looked at in terms of the test, the text, context, and legislative history tests, and it's looked at in terms of your past application of the code language. So we focused on the text. That's how we developed our case, and we also looked at the past application of the code provisions, which was developed during the Benton County Talks trash process. So that was looked at extensively. County staff did a memorandum how that was applied, and so we looked at that. So that is text and context. And but that deference is not unlimited. So the commission can't have to legislatively amend the criteria via an interpretation. You can't add something to the criteria that doesn't exist. You can't ignore something in the criteria that does exist. And I cited a case, this is in our rebuttal to the planning, rebuttal to the planning commission comments. It's called, and it's in the materials. It's a City of Salem case. Let's see if I can find it in here in my notes. Well, it's in the material. It involves the City of Salem, and what they had done is an application was filed. The applicant came in and asked for a zone change to allow commercial use on a particular property. There was that happened. It was approved. That happened in 2008. You know what happened in there. So they did not come back for the actual development to get the master plan for the development until about 5 years after that. And they proposed a commercial property that included a Costco. And the City of Salem went back to the testimony in the record of that initial proceeding, and there were representations by the applicant at the time that it wasn't going to be a Costco or a big box, any kind of other big box, large scale commercial operation. And so they denied the application for that reason. Went up to LUBA. LUBA said, no, you can't do that. I mean, if you wanted to preclude that kind of use, when you adopted the code language, you should have included that in. Costco is a commercial use. That's the use that it's allowed and otherwise meets all of the criteria for traffic sighting size. So they sent it back. So that's an example of that. Another case that's cited in my materials is one where the city of Portland was trying to site a homeless encampment over in the Inner East Side industrial area. And that the code provision there specifically prohibited mass shelters. And the city council adopted an interpretation that sort of said, no, that doesn't mean homeless in campus. And LUBA did not buy that and sent it back. So that's an example of attempting to like amend the code through an interpretation that will not be upheld on appeal. So the planning commission with regard to Jason, one of the planning commissioners argued in a position that was adopted as part of the findings that you should go out 8 miles or 5 miles for adjacent properties. And that does violence to the actual definition of adjacent. And I think ignores the fact that the area is supposed to gather those overall impacts. So I think, just from our perspective, an interpretation that would say adjacent means everything a quarter mile from the boundary of the landfill would not be supported by your code and would be beyond what your authority, your interpretational authority is under the case law. That's our position. So, so I've talked about deference. I think Ms. Schutz and Mr. Winterow did a good job of talking about the weighing of the evidence. It's very important for the, just skip through some of these slides here. It's very important that the commission, when it's deliberating, does weigh the evidence. So there's obviously conflicting evidence in the record. It's up to the commission to decide which is the most probative. We have the burden of proof, but if you decide that you disagree with our evidence, you need to explain that, and you need to point to the evidence in the record that supports your decision. The Planning Commission did not do that for most of its findings, and that was an error that would have been resulted in a remand on appeal. So it's very important to do. It's not only important to for you to have a defensible decision, whatever that decision is, it's also important for us because if you deny the application, we need to know what we can do in the future to come back in and fix it. So it's important for both present and future reasons. And then, and I know in this case, and it was mentioned in the staff report, we have many technical experts that helped us develop this application and put their professional stamps on the documents. That has been reviewed by the county's independent technical experts who have agreed that that demonstrates compliance with the applicable criteria. That's very strong and probative evidence in support of approval. And so if you make a decision that you don't agree with that evidence, it's important both from a legal standpoint and from an instruction standpoint for you to tell us explicitly why that is the case. And while I'm on evidence, I'd like to talk a little bit about relevance. Again, both Petra and both Ms. Sheets and Mr. Winterrowd commented on this. I'm sorry, we've been at this so long, I'm on a first name basis with everybody. Both they commented on this, but it's the evidence has to be both probative and relevant. So relevant evidence is evidence that goes to demonstrating compliance or lack thereof with the applicable criteria. Evidence that does not do that is not relevant. So again, as noted in the staff report, the issue before you tonight is whether this particular expansion complies with the applicable criteria. Relevant evidence of that involve whether the evidence submitted about this expansion demonstrates or does not demonstrate compliance. You're going to hear about violations that happened 30 years ago. That's not relevant. You're going to hear about, you may get some discussion because this came up with the Planning Commission. Well, why don't we close the landfill and send stuff out to Eastern Oregon? Well, that's not relevant either. The landfill expansion is expressly allowed under the code, and it's but subject to the applicable criteria. It's our obligation to prove that we comply, but it's in order to make that determination, you need to rely on relevant evidence, and that evidence has to be directed to the expansion itself. Conditions of approval.
I'm sorry, could I interrupt you for just
Yeah.
1 second? I wanted to do a check. Did we have an allotted amount of time that we set aside for their presentation? Is it? No. For the rebuttal, okay. I think
it was 1 hour.
1 hour, okay.
Right.
I just am curious if the information that's going down this road is, if the commissioners find it helpful, or if it would be wise to spend more time on some other stuff. I feel like a lot of the information that you've shared so far is all training that we've had when we first became elected officials. So you might have a better use of your time focusing on kind of the ins and outs of the application, but I will also leave that to your judgment. And if either of the other commissioners disagree with me, then let me know.
I'm fine with the presentation so far.
Okay, great.
I would say that I do have a long list of questions, and I know we have a lot of people who'd like to speak tonight. So again, I agree with Commissioner Weiss, however you choose to spend your time, but I do want to make sure we have time to get to our questions. But yes, and I agree. All of this is important information that we do consider when we're discussing this and when we're hearing testimony. So I understand the importance of emphasizing what is applicable and what isn't. So thank you.
Okay, thank you. Please continue.
Thank you. I got the message. I think that in terms of conditions, staff covered that adequately, and I'm going to turn it back to Brian and company to go through the slides about the substantive actions that we've taken.
All right, can everybody hear me? Yeah, see, I'm an old football coach, so I don't normally need a microphone. I can scream a long ways, so I'll try to manage this. Okay, so next up is myself, Brett Davis, General Manager here in Western Oregon, and Brent Lurch, and we'll be kind of passing it back and forth here to just give some examples of how we've gone through this process over 4+ years. We've listened, we've collaborated, and how we took that input. Along the way, you'll see some slides that are going to talk about the conditional uses that were suggested by staff. I'm not going to go into detail on those because they did a really good job going over that, so we'll try to save some time, okay? So again, this has been a 4+ year process. This started in 2021. And here's just kind of some of the first key things that we heard. The expansion was too large. Really what we got from that, it was too tall. There was visual impacts. And so again, we've reduced that by 50%. We were asked to engage in the community and listen to stakeholders. So we did that. We participated in a 10-month-long Benton County Talks Trash process. We held 2 in-person meetings where we allowed community to come in and participate, as well as an online question and answers process. We were asked not to expand the landfill onto any other property that was considered like forest conservation. So as we talked about, we've limited this expansion to landfill use only. And we were asked not to close Coffin Butte Road. And again, that was part of the reduction of the expansion. And actually, this expansion includes improvements to the road.
Good evening, Brent Lurch, Area Environmental Manager. Wanted to talk about groundwater and odor. So it's our belief that we have listened to, reviewed, read all of the concerns coming from the public. And it's our belief that we've met this criteria, which has also then been reviewed by county staff and their third-party consultants. And with this, we came up with a very robust list of conditions of approval, which we are all in agreement on. And some of those have to do with groundwater and odor concerns. So a couple things that we've heard and staff kind of touched on these, where we would have a negative impact on groundwater wells, potential releases or toxins going into neighboring properties, and then also a negative impact on neighbors. So using everything that we've heard and all of the modeling that we have done, we believe that these proposed conditions of approval can meet all of the concerns that the public has come out. And I think it's a very robust list of different conditions that we've already gone through tonight. Especially with the odor, our enhanced monitoring to have third-party review, as well as a good cadence and a very frequent cadence of our own internal staff looking at odor around the area and making sure that we're getting the right data and the correct data to understand where odor is coming from, whether that's from gas construction or operations, or whatever it is, and we can create a good plan to mitigate those odors and create a sustainable resolution to it, so that we can minimize the overall amount of odors and really be a good partner.
Okay, we'll go back to noise and fire. So some of the things we heard were, that the expansion would create noise and impact adjacent properties. You can hear from our technical experts that we believe that we've mitigated that. with some of the conditions of approval. One of the big topics of discussion was fire safety. We met with the Dare Fire and some of the local residents. And there are several concerns that were brought up, and you can see in here that we mitigated that with an additional fire truck. We acknowledged that, we had one truck and it was used at multiple sites for not only dust control, but other things. And so we've committed to the additional fire truck. But one of the things that was concerning was that there was kind of an accusation made of us that we were not reporting the number of fires correctly. And there was some statement of like 23 fires over the last several years. And so we actually did a public information request with the Dare Fire. And through their records, they supplied to us that since 2013, there's only been 8 fires that they've reported to that they had to support at the site. And 6 of those were actually between 2013 and 2018. So there's only been 2 in the last 7 years. And one of those was due to the open flame that we have removed and put an enclosed flame in place. So I feel like the systems and policies that we have in place help with the fire prevention and control. Again, I'm not going to go into detail because I know that everyone's, wants to make sure we keep this moving along, but these are, again, some conditions talking about noise, backup alarms, changing the backup alarms on equipment to ambient alarms. Again, you'll see there adding the 4,000-gallon fire truck. At the bottom, there's some additional annual fire training that we already do. And then another one that we agreed to do, even though we don't feel like we have a fire issue, but that we do agree that we will support the 24-hour on-site surveillance during red flag days. And we'll work with the Dare Fire on when those days occur. Operations and litter. Let me see, where am I at? Operations and litter. I know there's been quite a bit of talk about how to control litter. So on here, you'll see that we've committed to controlling the working face to approximately 2 acres. We also are proposing a tonnage cap. I know that there's been a lot of talk across the community that if this expansion goes through, that we'll have unlimited volume, and that's not the case. We have agreed to a 1 million per ton cap on municipal solid waste, and then an overall cap of 1.3 million, which includes the MSW as well. So again, just some more conditions of approval and just the detail of them here. Here again, some examples of litter control where we said we would support working face fencing, more fencing, perimeter fencing. I think one of the big ones is the litter management, where we currently work with the Benton County Sheriff's Office. Initially, when I started with the company, I was almost 9 years ago, we were only doing litter patrol on a quarterly basis. And so we recognized that wasn't enough. We heard, we listened. And so actually we're doing it on a weekly basis now, and we pay the Benton County Sheriff's Office work crew to do that on a weekly basis. And we don't have this in place yet, but we are in discussion with the Dare Village to also start paying them for some litter patrol on Independence Highway from Highway 20 to Adair Road. So, and then we're also aware that if we get this approval, that we'll have to do those arterial roads around as Tampico and Soap Creek as well. Oh, did I go too far?
Yeah, just lastly to touch on traffic, I know staff kind of touched on this a lot, but looking at how this expansion would interact with adjacent roads and roads nearby, and just wanted to touch on that. while our consultant did traffic counts in an analysis, we included landfill traffic, construction traffic, quarry excavation, and public counts of vehicles. And through this, we also included, growing population rates from the Lynn and Benton County transportation system plans. Additionally, we are proposing to add a turn lane as one of the conditions of approval, as well as, all improvements to Coffin Butte Road will be to ASHTO standards, or, what a more stringent standard if Benton County were to need something a little bit thicker as far as paving. So with that, I will turn it over to Mr. Roop for any closing comments, and then I'm sure we have a lot of questions for this evening.
Yeah, so thank you. And I know we didn't go into great detail during the presentation, but we do have experts here to answer questions that you might have. I will say that there's been a tremendous amount of work that's been put into and all the details that went into trying to quantify the impacts of the expansion. And all of those details were then reviewed by county staff and their third-party consultants, and obviously are here and recommending approval for this landfill expansion, which we would also ask you to consider and recommend approval as well. I think as I turn over to some of our third-party consultants, we just want to thanks again all of the effort that has gone into the review and the county's rigorous process to help make sure that we are understanding all of the community's concerns and doing the best job we can to address them within this application. So now we'd be happy to answer any questions you might have.
Thank you. Questions? Commissioner Shepherd?
All right, thank you. I have a number of questions, so I guess I'll go first. I'll start with compliance monitoring. So as our staff mentioned, condition of approval P1-9 on page 98 of the staff report talks about a proposed $80,000 a year from Republic Services to the county to for monitoring. And my first question regarding that is, how did Republic come to the number of $80,000 a year?
I think we looked at and worked with staff to help identify what we thought was an appropriate amount for the scope of work that would need to be done to help monitor the landfill, and that's how we arrived at it.
Okay, like what factors did you take into consideration? I'm just, if this were a math problem, like what work went into that, and why did you come up to 80,000? What monitoring are you talking about specifically?
Yeah, I don't know if we did a full inventory or bottoms up build up to get to that number. I think it was more of a general, how much time would it take to monitor the site? And you think about what an annual salary might be. And, whereas I don't think it is a complete full-time position to monitor the landfill during the construction, certainly $80,000 a year would go a long way in covering, some sort of part-time employee.
Okay.
Or, and what were you thinking of was a consultant, obviously, not necessarily a direct employee.
Okay, and which leads me to my second question on this, which is there are other conditions of approval related to monitoring, such as P1-1 that has some groundwater monitoring, P2-8, which talks about the active rookeries, and OP-4, which has odor. And in these ones, the applicant, you propose retaining an independent contractor yourself or training personnel to monitor conditions. So I'm guessing this part of the question is, why are those those aspects of monitoring and compliance in-house versus the 80,000 that the county, you're proposing to give the county out of house?
Yeah, and I'm open if anybody else has other comments, but okay.
Yeah, I mean, I think what we heard was from the community was that there was a lack of trust on us, and that they didn't trust that we would provide accurate information. And so that's why we stepped up and said, well, then let's, provide some funding so that the county can hire a third party to do that so that we can eliminate that as a factor.
Yeah, and maybe more directly to your question too, like I think the ongoing daily monitoring of odor is our responsibility and helps us, ensure that we can, like, I think knowledge is power there, and it helps us understand how to best mitigate any odors we might have as an example. And we do have a comment that we would pay for a third party specifically to come in and monitor and confirm that how we are monitoring odor is correct. And I think that's more of a very specialized service. And so perhaps a specialized consultant in that regard would make more sense.
Yeah, I think the core of the question I'm getting at here is that, I look at P2-8 and it says applicant shall hire a qualified biologist to monitor active rookeries. And then in the odor, applicant shall hire the qualified odor specialist. So I was wondering, what was the difference between the the things that the county is going to be monitoring under the 80,000 versus the things that that Republic is still, or Valley Landfills is still proposing to hire third-party consultants and be the ones monitoring. So I was just trying to draw that distinction there.
Yeah, Brian, if I could, I think for, if we look at like rookeries or like groundwater, for example, groundwater is probably the easiest where, every year we have to submit a report to DEQ. So, having somebody who takes the samples, does the statistics and the overall report, that's, it kind of goes to DEQ. And generally that's, on the onus of us. I think for the employee that's, going to be paid $80,000, I think that's more for overall compliance. So if said person wanted to review the groundwater monitoring report, that would kind of be under that umbrella.
Okay.
I'd add one thing too. Like, I think some of these conditions of approval were developed at a certain time, and then others were developed as we listened and heard. And so the condition of approval that is recommending the $80,000 to help hire a consultant to help overall monitoring was done after some of these other conditions of approval were written. If the commission would be more inclined to want to lump that all under one person, then I think that's something that we'd be open to. There wasn't necessarily a conscious decision to divide those responsibilities.
Okay, thank you. My next question has to do with water and leachate. So on page 96, the P1-1 groundwater condition of approval says that domestic wells immediately south of the landfill will be tested once a year for arsenic. So I think this is a brief three-part question. Why just the wells south of why just arsenic, and why once a year?
Yeah, and I may call on phone a friend here to help answer that question, especially if we start getting into more technical aspects of groundwater. So maybe I'll call up John Hauer from GLA and he can help us out.
Thank you.
Good evening. I'm John Hauer, Geologic Associates. We monitor all of the site monitoring wells for arsenic twice a year. The wells south of the proposed expansion area would be added to the program. Some of those would be the neighboring residential water supply wells, should they elect to have those tested. I think that it's really at their discretion whether they wanted to be included in the program, but we would suggest a minimum of once a year.
Okay, so you said a minimum of once a year. The condition of approval says that if they choose into it, the applicant will front the cost for once a year. So if they do more than once a year, is that cost borne by the resident, or?
That would be for you, Brian.
Yeah, I don't necessarily think so. I guess we could, again, if you have a condition of approval that you think a more frequent testing would be applicable, I guess what I would ask John from your perspective is, how frequent would we see changes, and, what's the right cadence on that kind of a testing, and would we see big variations over a 2-month period, a 6-month period, or a 12-month period?
Yeah, and basically south of the landfill, that groundwater is considered up gradient of the proposed expansion, meaning the water from the south flows down toward the expansion area. So it's not necessarily in a position to experience a release. We will verify that with a site-specific hydrogeologic investigation. But that once per year makes sense for background or up gradient monitoring.
And I think you just said that, well, I guess one of my other questions, but that does answer that question, so thank you. But one of my other questions was why just to the south? And you just said that the water flows. So why just the wells to the south? Is that just where the residents are, or is that where?
Yeah,
Okay.
yes, that's where the residents are. That's where the wells are that we're not currently monitoring.
Okay.
Yeah.
Thank you. Thank you. I have another question about the excavation. So, but it has to do with the water table there. So also on page 96, it talks about the distance from the base of the excavation site to the water table. And the proposal says that prior to construction, the applicant shall submit a justification for the proposed bottom elevation and the landfill demonstrating this condition has been satisfied. Is there a condition that the distance between the bottom of the excavation and the height of the water level is no less than 10 feet after you conduct the excavation? Will it be checked again? Because, you know, things blow up, right? So if you're using explosives, I'm just wondering, is that, it says in here that it will happen prior to excavation. So I'm wondering if that would be checked after excavation as well.
Yeah, groundwater monitoring will continue or will start prior to the development of the expansion area and will continue throughout construction and through the post-closure use of the landfill. So there's never going to be a time following adoption of the CUP that we wouldn't be monitoring groundwater. So it's an ongoing process.
And so that would give you a sense of the distance between the base and where the water table is.
Yes, it will.
Okay. And then I have a question for the chair. Do we want to do this like section by section or, okay. So I'm done with my water related questions. So I'll stop there for now.
Commissioner Malone? Or go ahead, sorry.
All right. Well, I'm going to jump around a little bit more than that, but so we'll start off with an easy one. In the conditions, it talks about hours of operation on Sunday. I assume that's kind of a theoretical, put it in case something changes in the future. Is that correct?
Yeah, I mean, it's really, we just wanted to reserve that in case there's an emergency, national disaster, something that, was special that we needed the hours of operation to be able to satisfy the community.
Okay. I told you it'd be an easy one. Well, I appreciate the discussion on litter that has been brought to our attention, and I would hope that this isn't just something in the future that some of these more robust litter patrols can be started up. This CUP process may go on for a while, but I think that would really help. As a tree grower, I appreciate the tree buffer, and I think that not only is it helps visually, but can help cut down on noise and depending on size of the trees and that sort of thing. Last up, where'd it go? The tonnage cap that was mentioned at 1 million tons per year. Going from memory, is that similar to the current tonnage cap?
Yes, it is.
And so that's in the conditions of going forward with this.
Yeah, so I think some of the concern was that the way the franchise agreement is worded, which isn't, as we learned earlier, necessarily applicable to this process, but regardless, we heard there was some concern that because in that language, if the expansion was approved, the current tonnage cap that's in the franchise agreement would then be extinguished or abolished, right? So I think what we've done here, and I would say this too, with or without the tonnage cap, there's not a lot of other waste shed that is going to find its way to Coffin Butte. In fact, we're budgeting for less tons next year than we had this year. So I know the perception is that if you do away with the tonnage cap, we're going to find a bunch of waste from somewhere and bring it into the landfill. And just functionally, that's really not going to happen because of the confined waste shed area. And there's other landfills that we would have to drive right by to get further waste into the area. That said, we welcomed and went ahead and made the proposal for the $1 million MSW and a $1.3 million total solid waste, and to include the MSW tonnage cap. Sorry, 1 million tons. My bad.
I translated that.
Sorry, misspoke.
All right. I think that's it.
So Commissioner Shepherd, I like your approach of going one by one. So I would say lead that, and any questions I have that don't already come up, I will check
Okay.
in.
Thank you. I think my next questions are for odor. So if our odor specialists. Thank you. Okay, great. And our attorney just reminded me that our consultants are still online. So, hello.
Good evening.
Okay, so I wanted to start with, see if I can find this. There it is. Okay. Exhibit 14 to the application, which is most of the odor related things. On page 18, which is page 22, it talks about Oregon state law prohibits businesses from emitting odors which cause a nuisance. Nuisance laws are implemented by DEQ, which has developed a strategy for responding to odor complaints and reported through an online tool. The strategy emphasizes early odor detection, voluntary cooperation, and the rapid resolution of nuisance conditions related to odors. And then it says, since ODEC or ODQ's nuisance odor strategy does not include a D, is it D/T or D over T? How would you pronounce that?
D over T.
D over T, okay. A D over T value for nuisance odor, the study used 7 D over T as the threshold for nuisance odor. So my first question has to do with the citation there. So it cites DEQ's tool, but it cites it as a hyperlink. And I asked our lawyers earlier today about this, and a link to a website does not constitute inclusion in the record. So is there a place in the record that you're aware of where the strategy from DEQ is actually, I would say physically, but it's very digital. Like, is it written out in the record somewhere?
Not that I'm aware of.
Okay. Okay. So with that being said, I just, the next question has to do with the D over T, and just starting with why you chose 7. Like what's the reasoning behind it? We saw the table that our staff showed us, right? Of 1 through, 1 million or whatever it was, and kind of how that gauges. But I wanted to know why the choice of 7 was made to determine what's considered a nuisance.
Okay, so with dilutions to threshold, you're trying to figure out how much of a dilution to a point where you cannot smell a sample of air. And we've done odor studies throughout last 30 years. And we've also seen other documents that reference 7 D over T, specifically California, and composting operations also was grappling with the same issue of how do you address a subjective perception of odor and translate that into maybe something subjective and apply that to a criteria. And so that's also, we've seen 7D/T in other places.
Turned it off. Okay. So on page 102 of our staff report, it talks about, this is one of the conditions of approval. So let me make sure I'm on, oh, look, I'm already on page 102. Look at that. Let's put it together. All right. It says if independent verification results, I might have misdone the page, but if independent verification results in a measured D/T of 4 or greater, applicant shall immediately take steps to mitigate the odor level measured by the independent verification. So the question is, what are those mitigation steps?
Well, the facility has a odor management plan in place. And so basically, if there's either a complaint reported or if they detect it through this specific condition, you basically want to look at, first you want to look at the on-site meteorological data to see where this event was recorded, what is the winds. Then you want to start to then look at your on-site operations. Is there anything unusual in terms of operations, activities, your normal mitigation measures, daily cover, your landfill gas collection systems? You basically just want to see, is there anything of note? And then if there's something within your control, then you want to address it, i.e. applying more daily cover or double checking to see if there's something going on with the flare system, et cetera.
So essentially, if the way that one would mitigate the a D/T of 4 or greater is by going through the controls that should already be in place and making sure that if they aren't adequately quenching the stench, applying more of those controls.
Exactly. You basically want to stop any odor as quickly as you can, because if something's already migrated offsite, you want to then track it back to its source and then try and stop it as quickly as possible.
Okay, thank you. And for the record, that was page 105. Sorry for the mix up there. So what would happen if you're daily monitoring, as outlined in OP-4B, if the D/T measurements were above 4 or 7? And I think you just answered that, but the reason I had that question was because the condition of approval says that if the independent verification says that it's over 4 over 7 or 7, where is it? If independent verification results in a measurement of D/T of 4 or greater, applicant shall immediately do things. It doesn't say that if the daily measurements are 4 or over, that the applicant will take measures. So I just wanted to make sure that the applicant would still take measures if the daily patrols caught that.
Correct.
Okay, thank you. Next question. So as the applicant, as the board, one of the things we have to discuss is what constitutes a serious interference, right? That's one of the terms that we need to define. And so my question to you as the applicant, and as you're looking at this odor constraint, many of the public comments had to do with odor. And I just want to know, what does the applicant consider a serious, does the applicant have an opinion on what a serious interference of odor would be and how often that would be? Would that be 1 day, 30 days, every other day, or so I'm just trying to understand if the applicant has an opinion on how many days constitutes a serious interference.
I mean, we have not discussed exactly what that definition would be.
Okay. Let's see. So this question starts off a little bit longer, but I'll try and summarize it as quickly as I can. But on page 32 of the application, it talks about essentially that weather changes how the odor works, right? We've all been people, we're all people out in the world, and we know how smells work for the most part. And that certain temporary landfill operations and weather conditions can temporarily increase odor. So in the study in in the application in example 14, I saw a lot of information regarding wind speed and direction. There's a lot of great wind maps in there, but I couldn't find a lot of information about how temperature and rainfall were used in the mapping. So the reason I bring this up is there was a piece of public testimony submitted by Nancy Yoloris on September 18, where it says that anytime there's a stagnant air alert or heat inversion, we smell the gases that are emitted from the landfill. The odor is so strong we can smell it inside our house. So this person specifically references the weather conditions. So I was wondering how weather was taken into account.
Okay, the dispersion modeling study used a model. So you have site-specific information, and then you also have meteorological data. So we had 1 year of on-site data that has things like the wind speed, wind direction, temperature, et cetera. And then you run the model through all those different conditions, and then the model predicts the peak 1 hour impacts at or beyond the fence line. So that's how that gets factored in.
Okay. So it uses you're saying the model that you used to run your analysis used a year of on-site data from the current landfill as it exists today to make a prediction with all the other factors in there.
I believe the data was from, I think around 2006. It was actually used in a prior modeling study for the landfill, but it was measured on site. It's a little different than the current monitoring station location. Is from a different location, but it's on site and representative of conditions.
Okay, so I just want to touch on something. You said that the 1 year, that was a 2006 data?
I believe so.
Okay. Okay. That's I think the end of my odor questions.
I'm sorry, it was November 1, 2004 through October 30, 2005.
Okay, thank you.
It's still 1 year data.
And is there any particular reason why you use that time frame from those dates?
It was meteorological data that had been pre-approved by Oregon DEQ.
Okay, thank you. And I wanted to ask about thank you, Commissioner Shepherd, for those questions. I wanted to ask about the odor monitoring, and will that be reported somewhere? Will it go on the website so folks can look at it, or be reported to the county, or how will that be available to the public?
Yeah, and Brent Lurch or Paul Koster, can you jump in here? How we would report that?
Yeah, I think, the daily or, third party reviewers, I would see where we could definitely share that with the proposed, our Benton County staff member. And, either we could post it or, that it could be part of that person's responsibility.
Yeah, I think the answer is like regulatory wise, we're not required to post daily monitoring results. I do think if that was something that was interesting or interested for the county to look at, we could, I know that we have a mechanism through DSAC for us to meet on a regular basis, and we could potentially use that as an avenue or a mechanism to help socialize those.
Okay, or perhaps put it in the annual report could be helpful
Yeah.
as well.
Yeah, if you want something more, obviously annual report's kind of a year look back, but if if it was something more frequent or real time, then maybe at the monthly or every other month DSAC meetings would be appropriate.
Thank you. And then I wanted to check and see if our county person or people had any comments to add.
So Mall Foster folks, if you are still hanging on, Chair Wise is wondering if you have anything to add, any answers to any of the questions. If you're out there.
I don't have, excuse me, this is Chad Darby. I don't have anything specific to add unless there's a question.
Okay, any specific questions for our friend here?
I guess my question is, how traditional is it to use data for this type of modeling that's approximately 20 years old?
It's actually not uncommon at all. What's really uncommon is to have site-specific data at all. And so when you do have site-specific data, which is because a lot of communities, when you're doing modeling, will believe that there's, a real micro weather system in their area, especially when there's topography. I mean, it's a real thing. I mean, I'm not making fun of that. And so DEQ does prefer to have on-site weather stations. But they're expensive to run, so most facilities will run one for a year and collect data. DEQ will approve it and use it nearly forever over pulling more recent data from a distant location.
Thank you.
Thank you. All right, should we move on to the next?
Yeah, I think I only have one more section of questions. Well, two more sections, sorry. The first one I think is just, has to do with fire, and I think it's very brief. In the record, the Adair Rural Fire and Rescue Chief Aaron Harris sent in a letter with concerns regarding impacts to his department's ability to provide services. This was for the Planning Commission's hearings. It was dated April 21st, and I was wondering if anyone from the applicants can point to any written response that there was to Chief Harris's letter. I know that we talked a little bit about fire today, but I was wondering if there was a written response to his letter.
No, there was no written response. We actually met with the Adair Fire Department at Coffin Butte with David Hackelman, and there was no concern expressed at the time about the ability to support. We had a great conversation. There was conversation about that there had been some changes in management and it'd be nice to have updated names and phone numbers. But the overall feedback was that the fire department had worked really well with our on-site operations manager, Brock Keenholtz, and there was never any expression of ability to cover. And I'll just follow that up by saying that, since 2013, there's only been 8 fires that they've responded to and helped extinguish at the site. So it's not a large burden.
Oh, it's already on. Thank you. My last set, do you have fire related questions? Okay. Okay.
So with I'm just curious in knowing what your plan is. So we're talking about this water truck. What is the plan if it needs to be used? Is there going to be a crew nearby on standby? How does that work?
Yeah, so we have a fire prevention plan at the working face. We do multiple things to help with fires if we have a hot load. So right near the working face, we have a place where drivers can dump if they have a hot load, and then we extinguish that with dirt. But the plan with the additional truck will be that one truck will be going around doing dust suppression, things like that. And this additional truck will be at the working face, and the employees on site will be trained to how to use it. It's got a hose on it, just like a fire hose. And typically when we get fires, it's something that comes out of the truck into a working face and we see it right away and we get it extinguished. And so that'll be the sole purpose is for it to be at the working face for use of the employees on site.
And you'll have adequate employees to work the truck.
Yeah,
okay.
Correct.
What happens if it's midnight and a fire is detected? What happens then?
Well, then we rely on the local fire department.
Okay, so your fire risk, you doing additional work to mitigate the fire risk is during your operational hours.
Yeah, we don't have anybody after hours. We've had a great relationship with Adair Fire. When they've been notified, we have people that just live north. Our operations manager, he's usually there, I think within 15 or 20 minutes. So yeah, we don't have any after hours detection. We did look into some portable, what we call like a fire rover, but with cell phone limitations and coverage, the provider said that it wasn't really adequate because of lack of coverage out there, and that There were several different versions, one that needed constant power and another one that needed solar, so that would work, but the cell phone coverage is the challenge.
Thank you. Back to you, Commissioner Shepherd.
Thank you. My last question has to do, or set of questions has to do with adjacency. And I think you mostly covered this, Jeff, in your start and an overview, but I just wanted to ask some similar questions that I asked of staff of why the applicant went for, you know, a property line definition of adjacent as opposed to a distance definition of adjacent.
We did so based upon the definition of adjacent, meaning abutting or nearby. So we went to, first we drew a boundary of, at staff's request, we drew a boundary around the entire active site plus the expansion area, which arguably isn't required by your code. Then we looked at the abutting property owners and added those in. And then because of in the definition in Webster's could include nearby properties, we added the properties abutting to that. And that produced the map that's in your record. We think that that is adequate to deal with the immediate abutting impacts, in part because of what Mr. Winterroud mentioned, is many of those, such as odor and noise, diminish the further away you get from that. And that the area question, the character of the area question, gets to the question about the impact on the larger area, which is 90 square miles. So we think that's a reasonable division, an interpretation based upon the code language, and that's why we did it.
Okay. I think that, yeah, that answers the questions that I have about adjacent. So I think that's actually the end of my list of questions for now.
All right, thank you. I have a question about wildlife. Could you just give like a very high level, short, you know, what considerations did you take into account for impacting wildlife?
Good evening. I'm Stephanie James from Turnstone Environmental. And considering the public concerns were mostly for deer and elk, big game, and then also for the rookeries, of course, and then looking at the potential for eagles nesting near and around the site. And so we did 2 years of studies on, actually 3 years for the heron rookeries were monitored. We looked for eagle nesting behaviors at the site for 2 years. And then we did a 1-year camera study looking at the use of the site as a wildlife corridor. And we did not find it as a significant wildlife corridor. We got many different critters that showed up infrequently and year-round use of deer. And then also we developed a protection program for the active rookery on site. And the new site for the rookery will, those have the recommended P1, that's phase 1-8 is the the phase 1 protections, which will basically work with requiring identification and protections. And the ODF&W and the county have approved of the wildlife protection program that is current on those sites. And then any new developments over the monitoring for all phases of construction and ongoing after that, we assumed that those protection plans would also be approved.
Thank you. Any other questions for wildlife? Since they have their expert up. Okay, great. Thank you. I think I had some questions about air quality and the visual and the litter, but I think those have already been answered at this point. Are there, just last call for any other questions? All right. Thank you.
Thank you for your time.
All right, so at this point, we are going to take a break. And I think staff's gonna switch up the tables a little bit.
Okay.
Before public testimony. All right, we are going to get started again. And Commissioner Shepherd, do you have a question?
Yeah, I have one quick question of staff. Is, to the best of your knowledge, is there any information in the record describing temperature and weather patterns from 2004 to today? Yeah, whichever, for Benton County or Adair Village or Coffin Butte?
Okay, so this is Jesse Winterwood with Winterbrook. No, we are not aware of that evidence and we can search the record for it.
Okay, thank you. That's all.
Okay, with that, we will now begin verbal testimony. I would like to take a moment to explain how verbal testimony will proceed so that everyone is prepared when it's their turn to speak. Names will be called in groups of 5. Each person will be identified by both their name and their assigned testimony slot number, so name and number. In each group, the first person called will proceed directly to the testimony table. The remaining 4 individuals should take their corresponding seats in the front row. Those chairs are marked in the order that their names are called. When it's your turn to speak, your name and number will be called twice. If you do not visibly move towards the testimony table, or for those joining via Zoom, if you do not interact with the webinar staff, by the second call, your opportunity to speak, including any time that has been ceded to you, will be forfeited. Please be mindful of your allotted time. If you have received additional time through time seating, you should know the total amount of time you've been granted. When you take the stand, begin by clearly stating your name and address for the record. Your time will not start until you have declared your name and address. If you received additional time, we will state that. Please wait for the timer to be set before beginning your remarks. For those that have seated time more than 2 minutes, it'll take our staff just a moment to sort of add up your time. And once that time is there, you can begin. At the end of your time, you will hear a bell. If you continue speaking beyond that point, you will be informed that your time is up. And if you continue to speak in the best interest of time and everyone here, your microphone will be turned off so that we may proceed in an orderly fashion. Please also be aware that the county's rules of decorum are posted throughout the venue. If these rules are not followed, speakers may be stopped or asked to leave the room. Lastly, as the chair of the Board of Commissioners, I reserve the right to cut off testimony that is repetitive, harassing, defamatory, or otherwise abusive. Thank you for your cooperation. We will now turn to testimony from representatives of governmental bodies who will receive 5 minutes each. And first up on that list is Pat Hare on behalf of Adair Village, number 1, and number 2 is Mayor Jan Kaplan.
I'm Pat Hare. I'm representing the city of Adair Village, 6030 William R. Carr Avenue, Adair Village, Oregon, 97330. I'm here on behalf of the city today, not for or against this decision, but to clarify some untruths and unfounded claims that were made on behalf of the city of Adair Village. I've listened to the records, I've heard the statements, our council has, and they asked me to be here to clarify them because they've actually started to cause us real damages. Those comments that were made, first off, Adair Village was not at the Planning Commission because we were neutral on this position. I, in 16 years, have had not one person come to a council meeting and ask us to represent them from the city of Adair Village, opposition or for this, not one time. So our council is focused on the development and what we have going on in our city. And since no citizens made this a priority, we were not there. There was claims made that we were not there because we had quiet money. This is very upsetting to me and to my council, my integrity, their integrity. We ended the claim, we even said that it was for water treatment. The only conversations that have been ever had with Republic is about wastewater treatment. And if anything, the city would be mad at Republic because they dropped out of those discussions back in 2017. And so we have absolutely not received any quiet money. The next item is that our housing values are dropping, which is the opposite. We actually were one of the highest in the state over an 8-year period. And we are continuing to develop right now. We've approved 300 more units and we're going to approve another 680. And they are selling as fast as they can be built. So another untruth. And these untruths have actually had our developer call us because we had somebody that was potentially going to buy in Benton County that wanted to know if our water was contaminated, which is the third issue that was stated in testimony. And we are regulated by OHA and DEQ. And we test our water several times a day. It is drinking water. And if we had an issue, I would be the first on Republic's doorstep and at your doorstep to testify to that. So in regards to this, we are neutral. We do have an opinion that if you were to approve or deny, this is an opportunity to use conditions of approval to clean up some of the other issues that we, like many others, have, which is garbage cleanup along our highways and Independence Highway. The leachate, let's look at a way to deal with that, but also know that to us, this decision does not impact leachate because leachate has to be treated for 50 years after this landfill is closed. And so we know this is an ongoing problem, whether you approve this or not, and we are working on these issues. I have helped develop a program where the Benton County Sheriff's Department works with them now and does cleanups. I'm working on some other projects that we get more cleanups on Independence Highway. So Adair Village is actively working with Adair Village on the concerns of Adair Village. The leachate, we have tried to look at developing a plant that treats it. Those discussions are no longer ongoing, but we're still very involved in those discussions. And so any comment that is made on behalf of Adair Village should only be coming from me, directed by my council. So I'd like you as decision makers to know, as you listen to more and after the statements I've heard, they are not supported by our council or by myself. If a citizen would like to speak on their own behalf from Adair Village, I recommend they do that. Thank you.
Thank you. Next up, we have Jan Kaplan.
Hi, I don't know if I'm on video or not. Can you hear me?
We can hear you. We don't see your video.
Okay, I'm not that much to look at anyway. Oh, there we go. Can I?
Yes, you're great.
Okay, is the timer started or?
If you would state your address for the record and then the timer will start.
Okay, my name is Jan Kaplan. I'm the mayor of Newport, speaking on behalf of our city council, representing the consensus of the council. For the record, I live at 35 Northwest High Street in Newport. We are in support of the appeal to the Planning Commission's ruling. And I really appreciate the opportunity to speak. I'll try to be as brief as I can be, because I respect the time that you folks are putting in. You have an incredibly difficult decision to make that clearly affects your community and the larger community of 6 counties, including Newport and I don't know, many local jurisdictions. We take some responsibility. We have not only recently realized how significant your decision is and how much it will affect the citizens of Newport. And so that's why I'm here. be addressing two aspects. One is that I support your planning staff's interpretation and instruction. And I think that makes sense in terms of there needs to be clear and concise ways of making land use decisions that allow folks to move forward. And two, that that the Coffin Butte Landfill is a critical regional resource. And I hope that we can come together as a region to accept responsibility and devise workable solutions. It seems it's been mentioned there, and it seems unfair that Benton is the burden that Benton bears for 6 counties. So that's something I think should be on the table. I've reviewed a great deal of the material in the Planning Commission decision and the staff report. Wow. You and your Planning Commission, your community development staff, and your citizens have done a remarkable job of bringing forth all sides of this decision. Arguments on both sides are well thought out, comprehensive, and articulate. Terms like significant impact, seriously interfere, and adjacent property appear to form the foundation of each side's arguments. Frankly, I sympathize with the folks who are living close to the site, but I urge you to heed the interpretation and guidance of your planning staff that conditional use permits must be grounded in the applicable approval criteria. Your planning staff recommendations seem to be based on the definitions arrived at by your BCTT work group. I strongly believe that to the greatest extent possible, our land use decisions must be based on clear and objective criteria. People of good faith can respectfully disagree about definitions, but as local government, we must honor our own codes, rules, and statutes, and we should not reinterpret rules to justify decisions. Regionally, the Coffin Butte Landfill serves as the solid waste needs of 6 counties. As such, the city of Newport appreciates the burden placed upon Benton County and its citizens. As a tourist destination serving regional tourism, Newport is aware of the burden of cost and impact faced by one locality meeting regional needs. And we recognize that, and we support you, and we need to seek some regional answers to sharing the kind of burdens that come to your county. I don't have immediate suggestions, but I think that's a critical fact. The loss of this facility would have a tremendous impact, certainly on us. The loss that would result, we send about 300 trucks a month to Coffin Butte. They're having to travel hundreds of miles further is not an environmentally sound approach to solving this problem. And so we're very concerned. And further, if you decided to closure, the rates, our rates, and as your rates, all of our rates would go up very, very significantly. And one of the concerns that I've heard from my council and my community is that that would likely or almost result in a major increase in illegal dumping. And that's because people won't be able to afford it. And that's just a reality that's sad but true. So we're requesting that you support the appeal of the Planning Commission's ruling, and we hope to be able to participate in any kind of regional problem solving, addressing the kinds of the issues that have been raised by you, your Planning Commission, and the whole process. Thank you so much for allowing us time to participate with you.
Thank you, Mayor.
Thank you.
You're welcome.
Okay, and if I have this correct, next up is number 7, James Mullane. Number 8, Diane Crocker. 9, Dennis Simmons. 10, Harry Myers. And 11, Jason Knope or Knope.
Good evening. My name is James Mullane. I'm here representing my family and I. I'm a Benton County taxpayer. I'm at 13350 Ira Hooker Road, just north of Kings Valley. I fully appreciate that I do not hold the popular opinion here amongst many of my friends tonight. Even though we disagree, I deeply respect them and I deeply respect their opinion. I urge you to look at the facts. According to the record, Republic Services has an extensive record of maintaining the landfill in compliance with environmental regulations. They hold themselves to a high level of environmental responsibility and accountability. By not approving the expansion, look at what the alternative is. A new landfill will need to be built in a nearby county, or we will be trucking all of our waste dozens or even hundreds of miles further to somebody else's landfill. What do you think that will cause? The cost of trucking is the #1 cost of waste management. We routinely call out the high cost of living, cost of housing, and houselessness in Benton County. Who do you think will bear the cost of trucking our waste that much further? Personally, my family can afford to pay more. Others, however, cannot. What happens when there is not an affordable landfill nearby? We already know higher CO2 trucking emissions, higher rates for customers, an increase in illegal dumping, illegal burning, and residents defaulting on their curbside pickup. The zoning at the landfill allows for the expansion. They've maintained compliance with environmental regulations, and your own staff, who are the experts in their field, have exhaustively reviewed the applicant's proposal to expand, and they are recommending approval. Please do not require a brand new landfill to be built elsewhere, unnecessarily spending millions just so we can simply say it's not in our backyard. We already have built a resource here. The applicant is eager to meet the concerns of the neighbors and keep waste manageable, environmentally responsible, local, and affordable for all. I urge you to accept the staff's recommendations and approve the expansion.
Thank you. Next up is Diane Crocker.
Hello, I'm Diane Crocker. I live in Philomath. My address is 2223 Applegate Street, Philomath, and I've lived in Benton County for over 50 years now. I stand before you in support of the expansion of Coffin Butte Landfill because, simply put, I'm old enough to remember a time when some Oregonians did not have a safe, affordable place to put their waste. Burn barrels, digging trench and burying garbage, or making a dump on a private land was common practice. None of this is ecologically sound or safe. As a grandmother to 11, I am proudly helping to raise the 6th generation of Oregonians in my family. My great-grandmother came to Oregon well over 100 years ago to homestead, and that land is still in our family. I graduated from Oregon State University in 1981 and applied to be a band teacher in Philomath School District the day after graduation. I got the job. I went on to teach for 40 years in Philomath, which is in Benton County. I'm deeply committed to Oregon. My parents bought a ranch recently, or I would say 25 years ago, and I remember them finding a dump on that land that they bought where the previous owner tried to burn everything, but what didn't burn, they put in the dump, and it was quite a mess to clean up. It's heartbreaking to see what people who can't afford the cost of disposal or have no other options to do to take waste management into their own hands. We all make garbage. I can recycle and compost and still have garbage. Without a professional offering the services to deal with our garbage, one could burn it, and that's not good. One could bury it, that's even worse. Or one could use common sense and be grateful for the service that Coffin Butte Landfill provides us here in Benton County. I strongly support the modest expansion at Coffin Butte because it provides a safe and affordable resource for all of us while bringing much needed revenue into the county. Upon learning about the Planning Commission's decision to ignore the recommendations of the Benton County's professional staff and deny Benton Republic Services the expansion, I immediately thought of those burn barrels and the unsafe consequences of trying to manage waste without an affordable alternative. I am grateful to Republic Services for providing a relatively safe and affordable system to take care of my garbage. It provides a great service to our community. Without expansion, I have learned that garbage would need to be transported to Eastern Oregon, which is the nearest landfill. I can't even fathom how high our bills would rise to cover those costs, and the pollution either trucking or placing garbage on a train would bring, and that defeats many of the arguments against it. With prices going up, utility rates along with inflation, the very last thing that we need is a higher cost for garbage disposal. I think instead of working against Republic Service who responsibly help us with our garbage, our time would be better spent lobbying the people who package our consumer goods that cause so much of this excess garbage and excess recycling, to pare down the waste and help us be better patrons of the land. Benton County could be a leader in this mission to cut the waste, kind of like Oregon was with the bottle bill. It is pretty simple. When the cost of disposal becomes unaffordable, people take waste management into their own hands, and that is not good. As a band teacher in Philomath, I learned to cut through the noise, no matter how loud it got, and it got loud, because I had a job to do. So I urge you to cut through the noise and approve the landfill expansion for the sake of our communities, because you too have an important job to do. Thank you.
Thank you. And it looks like Dennis Simmons and Harry Myers have canceled. I do have Jason Knope up next. Jason spelled Knope. Is Jason in the room? All right, we will move on. Let's see. Next, we have Kristen Mitchell, Linda Brewer. We have Steve Peters online. Let's see. And Meryl Kunkel and Cynthia Jacoby. Welcome.
Thank you. Kristen Mitchell, 727 Center Street Northeast, Salem, Oregon. Good evening, Chair Wise, Commissioner Malone, and Commissioner Shepard and staff. And my name is Kristen Mitchell. I'm the Executive Director and CEO of Oregon Refuse and Recycling Association, known as ORA. Thank you for the opportunity this evening to comment on the appeal of the conditional use permit decision at the Commission denying Republic Services application to expand. ORA supports approving the application to expand the landfill. ORA is a statewide trade association representing solid waste management companies in Oregon. ORA members collect and process most of Oregon's residential and commercial refuse and recyclables, as well as operate material recovery facilities, compost facilities, and many of Oregon's municipal solid waste transfer stations and landfills. This is my 34th year working for ORA, and it has been my honor and my privilege to do so. Coffin Butte Landfill is a member in good standing in ORA. That means that Coffin Butte Landfill follows a course of conduct that conforms to the legitimate interests and reputation of ORA, following the laws, ordinances, rules, and regulations applicable to solid waste management, and conducting business in a way that reflects well on the company as well as on ORA. Coffin Butte maintains environmental protection systems that meet or surpass all state and local requirements. This type of environmental performance is accomplished in this industry when sites are expertly designed and maintained, when ongoing investments are made to continuously improve operations, and when the right people are hired to do the job. It's important to note that Coffin Butte Landfill is a modern, state-of-the-art regional facility operating in one of the most highly regulated industries in the country. There is a long history that got us to this place. It used to be that most farms, and certainly every town, had its own dump at the end of a country road, a mile or two out of the way. Then in the 1970s, numerous environmental failures and costly cleanup litigation led to changes. In 1977, Congress passed the Resource Conservation and Recovery Act, or RCRA. Amended over time, RCRA required the closure of substandard disposal facilities. Any disposal facility staying in business after RCRA went into effect was required to meet the standards of Subtitle D. The technology to build safe landfills, complete with high-tech lining systems, advanced technologies to collect and remove leachate and gas, and ultra-sophisticated systems to monitor long-term environmental performance are protections that are good for the environment. They are also expensive, which is why individual communities could no longer afford their own landfills. Modern, safe landfills such as Coffin Butte come with a high price tag for initial capital and fixed costs. That is why most landfills today have a regional scope. Serving more than one community is what makes landfill operation economically feasible. Landfills aren't glamorous, but they are necessary. We can all continue to work toward waste reduction, and we should do so. It is also a relief to know that when something is disposed of, it is done safely and people and the environment are protected. With these considerations in mind, and with years of experience working with Coffin Butte Landfill as a reputable member of ORA, I respectfully ask that you approve the expansion. Thank you for your time tonight.
Thank you. And do we have Linda Brewer?
Good evening. I appreciate this opportunity to address the commissioners. My name's Linda Brewer. My address is 2630 Northwest Elmwood Drive in Corvallis. I've been a Benton County resident for more than 38 years. I'm a certified professional soil scientist, and I served on the Benton County Solid Waste Advisory Council for more than 10 years. I was unaware until I got here this evening that extra time had been given to me, but I've been assured that nobody's going to complain if I stop after 2 minutes. I'm here to speak in favor of the expansion of Coffin Butte Landfill. I've visited the Benton Clean and Strong website, and their tagline consists of 3 points: local jobs, local energy, and local control. And it's that latter point that I will address this evening. My neighbors who oppose the expansion of the landfill are sincere, but in my opinion, ill-informed. In the mid-1970s, Coffin Butte, the site was approved at the state level as a preferred location for a regional disposal site to serve Lynn, Benton, Marion, and Polk counties. Tonight, we continue to have local control over the fate of the landfill. You, our elected officials, will decide whether to approve or reject this expansion proposal. I'm not privy to the plans of Republic Services. However, it's entirely reasonable to imagine that Republic, as a for-profit corporation, would appeal to the State Land Use Board of Appeals if your decision is to reject the expansion proposal. Without knowing anything about the views of the members of that board, it is again possible to imagine that they would not favorably view an attempt by Benton County to renege on a longstanding agreement. Once the decision passes beyond the Board of Commissioners, we lose local control of the fate of Coffin Butte. Consider the possibility that the state could elect to expand landfill capacity beyond the level before you this evening. The opponents of this proposal could then find themselves with a far more difficult pill to swallow. For the good of us all, including those who oppose the expansion, I urge you to approve of the expansion of Coffin Butte Landfill, and I thank you.
Thank you. Do we have Steve Peters online?
Hello, can you hear me?
Yes.
Great, thank you. I don't think I have any video here, but as has been previously stated, probably better for you folks. I am retired from Republic Services. I don't work for Republic Services anymore. So there's really nobody that can stop me from saying anything I want to about the Coffin Butte Landfill and the company's operations in Benton County and the Willamette
Sorry,
Valley.
then could you state your address really quick? For the
Oh,
record?
I'm sorry. Yes, Steve Peters. Thank you. 2876 Northwest Angelica Drive
Thank you.
in Corvallis. I live here in Corvallis and thus Benton County. I've been here for 58 years. So as I was previously stating, even after a 30+ year career, I don't get free garbage service and I have to pay like everyone else. And even so, I strongly support the Coffin Butte Landfill expansion. After 33 years running route operations out of the Corvallis Hauling Division at Republic Services, I now spend most of my time volunteering and as a musician in the Corvallis Community Band and as a PA announcer for boys and girls basketball and football games at Crescent Valley High School. Go Raiders. I was born and raised here in Corvallis, and it's where I raised my 3 kids. I attended Crescent Valley High School and Oregon State University from 1986 to 89, where I met my wife, who currently works at Samaritan Health. I studied community health with a minor in occupational safety and played center for the Oregon State football team. Go Beavs. My parents met here in 1959. My dad was the general manager and assistant publisher of the Corvallis Gazette-Times, and my mom taught in the home ec department at Oregon State University and was a former senior first citizen here in Corvallis. As a supervisor, you know, it's very similar to being a coach and not all that different. You do a lot of training, encouraging, watching, listening, and most importantly, keeping your people safe. Just like players, the 27 garbage truck drivers I supervise will tell you more when they feel seen, heard, and taken care of. I started working at Corvallis Disposal after the spring of 1987. They would always hire a football player for the summer. And strangely, that next season, my senior year, I remember my last game for OSU was unfortunately in Autzen Stadium, which coincidentally is built on top of an old landfill. So go figure. Before I graduated, I got offered a full-time year-round job. And in the winter of 1990, an opportunity came up to run their medical waste division, which soon included businesses up in the Portland metropolitan area, which tied into my degree and experience. I've always been a safety guy, from making sure my teammates and student athletes stretched before practice to when I served on the Corvallis Little League board and would fill out paperwork when a kid broke his arm. So it was a great fit for me, knowing Republic's passion and investment in safety. People don't realize how dangerous the solid waste industry is. It's the 4th most dangerous occupation. Safety at Republic Services is job 1, making sure drivers get home to their families every night. The extensive 10-week training for new driver hires is second to none, and ongoing weekly safety training continually puts our drivers and employees in the best possible place to succeed. We additionally did 2 to 3 in-cab ride-alongs with drivers every week to mitigate problem areas and make suggestions on how to offer the best service en route. These are good jobs where you can go home to your family every night, and our locally raised team works to make sure they do that safely. If you haven't looked at the Republic Services logo, it's a star that's actually made up of 5 R's in a circle. Those 5 R's represent being respectful, responsible, reliable, resourceful, and relentless. We would ask our drivers to embrace those standards in everything they do. And of course, safety is always the top of the star. To this day, I'm proud of how we showed up for our workers and the community during COVID. Directives came down from the corporate office to provide above and beyond support for community food shelters like the Gleaners with catered in food, sending meals home to our employees, feeding our people, and to do so supporting local restaurants, having them bring in catered food and supporting their businesses, who, by the way, made it through COVID, not needing a price hike because their waste is traveling 200 plus miles. So you don't have to listen to old football players and garbage men like me, but here's what I'll tell you. The local men and women who show up for work at Coffin Butte and the Corvallis Division do good work day in and day out and care about their communities. Republic Services is a great company with a diverse workforce. I can remember that the promotion of 2 female office managers, one became a GM, the other one became a regional operations, was in an operations role. And of course, Mary was one of my drivers and one of my best drivers, very efficient, very safe. So it was, it's just been a very diverse and very open and supporting environment. They pride themselves in doing things the right way, never cutting or being intolerant of cutting corners, whether it's the equipment maintenance or safety training or taking care of its people. I would like to thank Chair Wise, the Benton County Commissioners for the opportunity to speak in support of Republic Services and this expansion project. Thank you very much.
Thank you. Next up, I have listed online Merrill Kunkel, but I don't see that they have checked in. Is there a Merrill? Oh, there we go.
Good evening. My name is Meryl Kunkel, and I am a resident of Yamhill County. I live at 2505 East Redwood Court in Newburgh, Oregon. I hold a degree in conservation and resource studies with a focus on environmental policy from UC Berkeley. My interests have always centered on the intersection between environmental protection and economic feasibility, finding solutions that work not just in theory, but in real communities. I think it's fair to state I am generally not pro-landfill, but we have to be honest about the reality of Coffin Butte as the only regional landfill serving this area. Oregon makes siting new landfills extremely difficult, and no short-term alternative exists at the present. If this expansion is denied, the waste does not go away, it just travels further. That means more long-haul trucking, more diesel emission, and significantly higher costs pass directly to ratepayers. Families and small businesses are already struggling with increasing costs. Refusing this expansion adds a financial burden to residents who are already stretched. Environmental policy that ignores economic reality is not responsible policy. This is a rock and a hard place discussion. Oregon can and should continue to invest in better recycling programs, stronger producer responsibility policies, and waste diversion strategies, but those are long-term solutions. The proposed expansion is a short-term bridge that comes with new environmental quality conditions, strengthening protections. It also generates millions in local revenue that fund essential public services. I understand the instinct to resist expansion. It feels counterintuitive to sustainability. But when addressing environmental policy, we must live in a version of reality that may look to the future, but addresses the right now. Coffin Butte is not a forever solution, but it is the pragmatic bridge to the next one. Thank you for your time.
Thank you. Next up, I have Counselor Cynthia Jacoby. Are you online?
Yes, I'm here. Thank you. Cynthia Jacoby, Newport, Oregon, Newport City Council and Council President. I live at 428 Northwest 17th Street in Newport. I want to thank you all concerned this evening for your respectful and thoughtful forum for this topic. I also admire your endurance this evening. Stay strong. I want to support everything which my mayor, Jan Kaplan, spoke about. And I especially want to emphasize the fact that we are small rural towns in Lincoln County, and we are really afraid that people will start more illegal dumping. We just seem to have gotten a handle on that lately. There's been a lot of enforcement and education also, but that that may fall away a bit. I urge you to expand the life of Coffin Butte and to give adequate time for things like the Recycling Modernization Act to really take effect and help all of us reduce this massive flow of trash for which we are all responsible. Thank you all for your efforts.
Thank you, Counselor.
Thank you.
Okay. So the next group looks like Brent Pelowski and Mayor Bill Rosacker, Bubba King, Walter Chuck, and Counselor Hall.
Brent Pulowski, 3515 Northeast Canterbury in Corvallis. And my opinions are my own, not anything or anyone I'm associated with. I support the expansion. Benton County can show leadership in maintaining waste management solution. Expanding the landfill makes sense until Oregon declares a different long-term strategy for waste handling. The waste demand only seems to increase with time. When landfills are gradually closed, it pushes the cost to the consumer. Simply phasing out or shutting down a landfill does not magically make the trash or the concerns disappear. It only displaces the waste. The closing of the Brooks incinerator, for example, was, in my opinion, short-sighted, which diverted waste to Coffin Butte. This is an inconvenient fact when counties attempt to push their waste problem to another county. Although environmental concerns are cited on any solid waste disposal debate, we cannot recycle our waste. We cannot recycle our way to zero waste. You know, for example, on the Brooks incinerator, you go talk to farmers over in Hubbard and surrounding areas. One farmer told me, well, how do I get rid of a cow now? I have to haul it all the way over the Coffin Butte. And then I've heard other opponents say, well, why don't we make transfer stations? Well, who wants to pass around the dead cow? Regionalized landfills are a fact of life. Landfills are now regionalized because of their regulation and barrier to entry. Gone are the days of each town having their own dump. Taking waste from other counties is an inconvenient fact of regulation and a barrier to anyone who handles solid waste. Those who criticize regionalization simply ignore the effort and expense required to permit a landfill. Alternative or disruptive waste alternatives take years to decades to complete, and expansion is a good plan until then. Other than shipping waste long distances, there's no other option right now than landfill the waste. If there was ever a new technology to replace landfills, an expansion makes sense until we can modernize waste management. You know, many waste alternatives might sound good on paper, but implementation is not so easy. A lot of the alternatives I've heard, they're cumbersome and expensive. Residential customers do not want to support expensive alternatives that provide little benefit. Everything we do in life generates waste. Well-run landfills an asset to deal with this waste. Republic Services has acquired many dump sites and modernized them into landfills with up-to-date liners, leachate containment, and methane capture. When one goes and asks the landfill users, the people who are lined up dumping waste at the landfill, the majority of them see this landfill as an asset. You just go ask the farmers and the contractors and landscapers and other people who are tipping their waste each day. Republic Services has listened to input from the public and has improved the ease of access for the disposal. No longer is one required to drive to the open face. Most small loads are able to tip right at in the transfer area, and this has improved time and safety. Republic Services has removed all the legacy unlined cells of Coffin Butte. Little known among many and ignored by opponents, Republic Services completely excavated and moved the legacy dump site to the modernized portion of the site. This was a final step of mitigating the leachate drainage into the unlined areas of the landfill. And reportedly, when they dug up the newspapers from the 40s, they were still readable. I mean, how can anybody be against a company willing to absorb the costs to modernize and reduce the leachate risk? And then in there, Republic services, they're regulated. Benton County should trust the state and federal regulators for landfill safety and environmental impact. You know, Oregon is a state that touts itself on being environmentally progressive. If Republic Services is not following protocol like some claim, then our ire should be directed at the very agencies that were chartered to oversee and protect us. There's been recent concerns over PFAs and other forever chemicals that spawn from the breakdown of synthetics and plastics. Although it's argued that these chemicals are concentrated at landfill operations, these compounds are in everything we touch. PFAs are currently under research. Information on health effects are going through the scientific learning and the regulatory process. Let us trust our DEQ and EPA to take action when appropriate. How to regulate PFAS should be on the agencies chartered to do so. And in closing, you know, I toured this landfill, you know, near 35 years ago, and it was communicated back then that the long-term plan was to expand the landfill. I mean, this was no secret, you know, to anybody around in the county or who bought property near the landfill. I mean, this has been known. You know, they were very willing to share that information. Like I say, even 35 years ago when I toured the landfill. So thank you very much.
Thank you. Do we have Mayor Bill Rosacker online? You're muted. Mayor, you are muted. We cannot hear you.
How about that?
Perfect.
Thank you. My name is Bill Rosacker. I'm the mayor of Newburgh. I have not brought this matter in front of council, so I'm speaking for myself. I'm not speaking for our city council or our city staff.
Could you state your address for the record, please?
2605 North College Street, Newburgh, Oregon.
Thank you.
Coffin Butte isn't just a Benton County issue. It's a regional solution that's vital for the long-term sustainable management of solid waste across our part of Oregon. Communities like Newburgh rely on this facility every single day. At our own transfer station, we're already struggling with capacity, made worse recently when a nearby center stopped accepting flatbed trucks. That simple change has caused backups, delays, and real costs for working families and small haulers alike. I can't even fathom the impact of this region. We're left without a landfill capable of handling our waste responsibly. This was never meant to be the burden or decision of one county alone. Back in 1997, it was a joint decision by 3 counties to ensure the regional waste stability. That partnership and the foresight are exactly what we need to honor today. As mayor, I'm deeply concerned for the working Oregonians and vulnerable low-income families who would bear the brunt of poor waste policy. It is simply irresponsible to place the theory and ideology over reality and practicality. Decisions like this must consider the full region and the very real people we serve. Thanks for what you do. I know making decisions is difficult. I wish you luck, and thanks for your time.
Thank you, Mayor.
Thank you.
Next up, I have Commissioner Bubba King.
Hello, commissioners. Commissioner Malone, I don't believe we've met, but I've definitely had the pleasure of your counterparts with you. My name is Bubba King, and I am a Newburgh, Oregon resident. Good evening, commissioners, and thank you for allowing me the opportunity to speak. I'm Bubba King, Yamhill County Commissioner. I want to start by saying I really appreciated speaking with people on both sides of this issue. I had originally planned not to weigh in verbally, but I felt it was more appropriate to listen and to learn. But after hearing repeated questions about why I've been asking questions and inquiring about this conditional land use permit, I decided it was important to share publicly why I'm engaged and why I care deeply about this process. As county commissioner, I'm always mindful about stepping into matters that fall outside my jurisdiction. I respect local authority, and I know firsthand the responsibility that comes with sitting in your chairs. But that's exactly why I felt compelled to offer my perspective tonight. Because while this decision rests with Benton County commissioners, it will have long-lasting impacts. Let me say that differently. Decades of impact on my constituents, on our local businesses, on our health providers, and our farmers who work the land in Yamhill County. My constituents, cities, farmers, and businesses in Yamhill County are customers of Coffin Butte. Many of the people I represent rely on this landfill's continued operation. And because of that, the decisions made here today don't stop at Benton County line. They reach into every surrounding county that depends on a reliable and sustainable regional waste solution. What concerns me most is that this has not become a regional discussion amongst elected officials, one where we sit down, balance the cost of living pressures on our residents and businesses, and also thoughtfully consider the environmental and community concerns being raised by the opposition. There's always room for collaboration and compromise, but that requires a willingness to truly seek and input and understand one another's challenges. I believe we've reached a point in Oregon where it's easy to let ideology overshadow practicality. Meanwhile, our people, especially working families, are feeling the squeeze. We're watching taxes rise across the state. We're seeing the federal budget make cuts that directly impact Oregon's local programs and communities. That means we, at the local level, have to be especially diligent. That means we must take care to make the decisions that we actually can control, the ones that affect revenue, expenses, and the cost of day-to-day living for Oregonians. When I think about Coffin Butte, I don't just see a landfill, I see a piece of essential infrastructure, a regional necessity that allows us, our communities, to function responsibly, sustainably, and affordably. And while there are legitimate questions about oversight, expansion, and accountability, I believe the conversation should be rooted in understanding that this site serves an entire region, not just a single jurisdiction. So tonight, I simply want to express my hope that regardless of how this particular decision lands, we can begin to engage as a region in more intentional way about waste disposal, sustainability, and the cost management. I would welcome that conversation and want to be a part of it moving forward. Thank you for your time and for the thoughtful consideration of the broader implications of this decision carries in front of all of you. Thank you. Good night.
Thank you, Commissioner.
Thank you, Commissioner King.
And I've been notified that Walter Chuck is not online or in the room. And so we will move on to the next group. We have Counselor Hall, Amy Thompson, Rob Thompson, and Steph Newton. Counselor Hall, are you online? Okay.
Hi,
Welcome.
can you hear me? Okay. Hi, my name is CM Hall and I live at 720 Southwest 6th Street in Newport. As previously expressed by our mayor and council president, the Newport City Council is in favor of the expansion. We come to you as leaders who very much care about, who very much care about the beauty of our state and the care of our environment and the climate impacts. We're here to ask for a measured expansion. We are particularly sensitive to this as a rural community who we believe will be disproportionately impacted by the decision to close. Without a gradual plan for closure, waste disposal costs will go up. Wages aren't keeping pace with costs, and folks in rural communities like ours are more impacted by these increases. Currently, the median income for Lincoln County residents is $61,000. The median income for Benton County residents is $76,000. Given where salaries are, I'm not optimistic that we'll be able to absorb the fee hikes. Without the expansion, it will mean more trucks moving more often, more miles along winding highways to haul our waste further away. And those haulers are making 300 trips a month right now just to go to Coffin Butte. Higher vehicle emissions and more road congestion doesn't even mention imagining the environmental costs of establishing an entire system and infrastructure to move all that waste hours away through ice and snow and mountain passes to a new site. We recognize the inevitability here and are simply asking to slow the process, expand now, allow more time to adjust to this transition. And lastly, I want to express a request that if any future regional decisions are to be made that impact us, that we be read into the discussions that are taking place. We respectfully request that you approve the application for the proposed expansion. Thank you. And as I would like to echo the mayor and council president of Newport, we appreciate the energy and time you're taking with this. Thank you.
Thank you, Counselor.
Thank you.
Is Amy Thompson online? Welcome.
Welcome. Thank you. My name is Amy Thompson. I live at 460 Southeast George Street, Newport, Oregon, 97365. Good evening, Benton County Commissioners. My husband and I are operators of a third-generation family-owned waste hauler, Thompson Sanitary Service. We are the franchised hauler in Newport, Oregon, and our company has been hauling waste to Coffin Butte Landfill since 1993, when our own landfill in Agate Beach was closed through the RCRA legislation. I am an environmentalist and proponent of this expansion. As a waste hauler, we witnessed firsthand the effects of society's consumerism, as the per capita waste generation by citizens has already shortened the lifespan of Coffin Butte and has moved up our waste timelines for the 6 counties that haul to this facility currently. I educate our Newport community about living sustainably and have been the sole recycling educator for the past 20 years. I am very familiar with the landfill, having visited and conducted tours there for Newport school children for 10 years, as well as Lincoln County's elected officials. Landfills like Coffin Butte are a necessity of our modern society. By denying this expansion, it prematurely closes the landfill and severely limits our time to create and explore a more economical and environmental solution for our waste. It takes years to put waste plans in place due to permits, inter-county and state coordination, transportation, all of it. Lincoln County households are in financial hardship, with 15.7% of our population living in poverty. This would create an undue stress on our rates and, in my opinion, would increase the level of illegal dumping in our county because citizens won't be able to afford waste service. It will also increase the cost for businesses and will likely see price increases on virtually all services in Lincoln County. The denial of this expansion benefits a small group of people while ignoring the larger population who aren't testifying tonight because they are simply surviving. Thank you.
Thank you. Is Rob Thompson online? Welcome.
Yes, good evening. Can you hear me?
Yes.
Okay, thank you. Yes, I'm Rob Thompson. I'm the president of Thompson Sanitary Service, third generation family-owned business here in Newport. My address is 460 Southeast George Street, Newport. Good evening, commissioners, and thank you so much for your time. I've heard some really good input. I hope that you'll have a chance to go back and review this. You know, for Lincoln County, the Coffin Butte Landfill is a critical piece of public infrastructure. It allows our family business to manage solid waste for our residents here in a responsible and sustainable manner. I'm going to keep it really simple because you've had some really good input, but I wished I had a magic wand. The fact of the matter is, as a society, we still produce solid waste. I would love nothing more to only haul recycling and compostable materials, but we're just not there yet, okay? So we haven't crossed that finish line. And what we really need tonight in your thoughtful decision-making is a dial and not a switch. We need more time as an industry and our technology to move away from landfills as we know them. I would love that, but we're just simply not there. We have an excellent partner in Benton County through Republic Waste Services to operate a state-of-the-art landfill. As my wife mentioned, that's why Agate Beach was closed, and we're fortunate to have that resource in Benton County. I trust that Oregon DEQ will continue to increase their regulation and oversight. I also trust that you, as the Board of Commissioners, will listen to your staff and their thoughtful recommendation to extend the expansion, albeit a modest expansion, to Coffin Butte. And so with that, I just really want to thank you for your time. I'm open for any questions you may have in the future. And I really believe in the testimony you received tonight from all of the concerned citizens. So thanks again for your time.
Thank you.
Thank you.
Albany City Council President Steph Newton.
Good evening. I got out of my council meeting in time to jet on over here. So my name's Steph Newton, address 2060 Southwest Ferry in Albany. So my name's Steph Newton. I serve on Albany City Council as the council president. I represent Ward 1, which includes North Albany, which is Benton County's second largest city. It's over two times the size of Philomath, and that's a big reason of why I care about this. No, don't mean the shots fired at Philomath. Love you guys too. And I know Commissioner Shepherd, I know you know how vocal North Albany residents are. I swear I'm making friendship bracelets for some of them. So I've heard from so many of my constituents, particularly about this issue, and that is why I'm here, to share what I've learned after reviewing the reports and listening to my constituents and community. I want to be clear, I'm speaking just as myself. The Albany City Council made no choice whether to endorse or not endorse this. So yeah, as I mentioned, I've spent a lot of time reviewing both the Planning Commission's findings and the county staff report, as well as thousands of pages of testimonies submitted over the past year, a whole bunch of, Facebook posts, everyone's websites. I was digging in deep. I understand and respect the passion and the concerns that this topic has stirred in our community, and I've done my homework. After that research, I've come to agree with Benton County staff's recommendation that this expansion should move forward with the 34 conditions they've outlined to safeguard our environment and public health. Now, I'm gonna be honest with you guys, I'm the kind of person who tries very hard not to create waste. I compost, I recycle, I reuse soap, like every single jar. My husband hates that I have a whole cupboard in our kitchen that's literally just jars. I rinse out and reuse all my yogurt containers. I even have a 42-gallon tub in my garage filled with red wriggler worms, and I compost all of into there. My garden loves it. I love it. My son loves it. It's really win-win-win. Totally want to endorse some red wrigglers for everyone. And yet I still do create trash as hard as I try not to. And I know every household here in Oregon, every business, every city, the question isn't whether or not we generate waste, it's how responsibly we handle it. So that's why I think this discussion has to be rooted in realism as well as responsibility. The Coffin Butte Landfill serves nearly 1/3 of the Mid-Willamette Valley's waste. If the expansion is denied, the waste won't vanish. It gets trucked hundreds of miles away to other landfills, often in communities with fewer resources to manage the impacts. That means more diesel traffic on our highways, higher transportation costs, more wear and tear on the roads we just funded through Oregon's new $4.3 billion transportation package, and increased greenhouse gas emissions from long-haul transport. Keeping disposal local is the more sustainable, fiscally responsible option. It keeps jobs here, keeps dollars circulating in our own communities, and allows Benton County, rather than some other counties that maybe I wouldn't trust them to directly oversee environmental safeguards, instead of relying on other jurisdictions with different priorities and weaker oversight. The county staff report makes clear that the proposed conditions address the major concerns raised. groundwater protection, odor and noise management, which really, let's be honest, it's probably from ATI. We're working with that in City of Albany, and that's directly east of Adair Village. Litter control, lighting limits, and wildlife protections, including for the great blue heron rookery nearby. These are not superficial fixes. They are enforceable, measurable, and based on technical evidence reviewed by experts. And beyond environmental safeguards, the economic benefits are significant. The expansion would generate millions in discretionary revenue for Benton County each year, funds that can go directly towards roads, bridges, and environmental programs at a time when taxpayers are already being asked to contribute more for infrastructure improvements, turning away a project that creates local revenue for those. And I have a lot more to say, but I only have 5 seconds left. So thank you so much for your time and consideration. I'll email you guys the rest.
Thank you, Counselor. And if you want to submit all of that, you can give it to the people at the table out there.
Which table?
Out front, next to the door. And that concludes the testimony of proponents. And we have 20 minutes left that's scheduled for tonight. So we will just jump right into the opponents. First up, Robert Kipper, and then Virginia Scott, Maya Abels, Peg Herring, and Jeffrey Kleinman.
Good evening, Commissioners Malone, Shepherd, and Chairperson Weiss. My name is Robert Kipper. I live at 2133 Northwest Beechwood Place in Corvallis, Oregon, and I am against land use application LU-24-027. I am a current member of the Benton County Disposal Site Advisory Committee. I'm not here tonight representing DSAC, but rather my family's 4th generation 80-acre woodlot that directly borders the southern landfill buffer zone. As a member of DSAC, I've had the opportunity to meet and work with the employees of our current waste disposal franchisee, Republic Services. I've found them to be hardworking, good people, fully engaged, contributing members of our community. I've not had direct interaction with the Benton County planning staff other than reading their reports regarding land use application LU-24-027. The volume of work necessary for this application was immense, and this was on top of their already full plate of day-to-day tasks moving the county forward. I'm very impressed with their dedication and the very long hours worked in the service of the citizens of Benton County. Planners, by their very nature, are optimistic problem solvers with the end goal of getting to yes. Working closely with applicants, the give and take revolves around how can we make this happen? They wade into the weeds with the applicant, ticking off boxes, but this detail work can lead to losing sight of the big picture. Big projects create their own momentum. After investing tremendous time and effort, 5 years now, having a project not move forward feels defeating. Controversial and marginal applications end up with an abundance of conditions of approval. Compliance with these numerous conditions of approval is very difficult to ascertain, let alone remedy, in a reality of self-reporting and diminishing governmental oversight. The applicant is very good at driving profit and shareholder equity. Their relentless pursuit of return on investment has resulted in their stock price rising over 400% in the last 10 years. Land use application LU-24-027 is not about keeping Benton clean and strong. That's just an expensive 11th hour professional public relations effort. No, LU-24-027 is about business survival in the Pacific Northwest. Coffin Butte is Republic Services' only card to play when competing against their better situated, forward-thinking competitor, Waste Management Incorporated, and their state-of-the-art Columbia Ridge landfill. Crossing Coffin Butte Road is crossing the Rubicon. There will be no turning back. Once encamped on the south side, further development is inevitable. This would begin by vacating the section of road between the two landfills, the old one on Coffin Butte and the new one on Tampico Ridge. This action would not be subject to public review. After that, the two become one. The zombie proposal of 1994 rises from its grave and becomes reality. 80 years ago, World War II ended. 77 years ago, most of Army Camp Adair was decommissioned and closed. That same year, 1948, my grandfather, H.E. Carlson, was looking for land to purchase in the Willamette Valley. He looked throughout Lane, Lynn, and Benton counties. After reconnoitering the east slope of Tampico Ridge, he found what he was looking for: water, 3 springs to be exact. After purchasing the 120-acre slope, he moved a house that was on the property a quarter-mile north, directly in line with the middle spring. He installed a spring box up the ridge at the spring head, and using Army surplus pipes, fittings, and 2 repurposed boiler tanks, he created a gravity flow system to his house. Below the North Spring, my grandfather built a pond for the livestock that soon grazed on the land. Our water right to the springs and pond is recorded with Oregon State Water Resources Department under the certificate number 70845 HB 2153. All of the spring heads are at least 2/3 of the way up the ridge. The North Spring only 5 yards from the property line with Republic Services. The very fact that a spring head exists on Tampico Ridge is evidence of fractured zones in the underlying basalt. If Republic Services is allowed to dig into the side of the hill as close as 250 yards from our property, and their excavation connects to another fractured zone lower down, very likely, that will create an easier path for the water to drain out the side of the hill. This will cause the flow to the spring higher up to decrease or stop entirely. A permanent, forever change to the hydrology of our land. Diminished spring flow lowers the water table, slowing the growth rate of our cash crop, Douglas fir timber. This translates into reduced board feet at harvest, reduced value, and reduced timber tax. Diminished spring flow will mean the end of our year-round pond, the end of wildlife habitat, and the end of year-round livestock grazing potential, a significant hit to our property's value, and the very reason that my grandfather, Hilmer Eric Carlson, coveted this site. As far as I can tell, Republic Services has no plan to address this issue. Any condition of approval to develop a plan after such an event has occurred is the very definition of closing the barn door after the horses have escaped. There is no known, reliable, permanent fix for this damage. This is an unacceptable, and let me reiterate, permanent change to the use and character of our adjoining property, Benton County Code 53.2151. These springs of my grandfather are powerful. These sacred springs of the Kalapuya, we've discovered obsidian scattered around them. These springs give you, the commissioners of Benton County, the power to say no to land use application LU-24-027, to say no, just as your planning commission unanimously voted this summer, to say no, as the planning commission unanimously voted in 2021, and to say no, as Commissioners Kent Daniels, John Dilworth, and Madam Chairperson Pam Foltz unanimously voted in 1994. The ancestors will be pleased, and future generations of Benton County citizens will proudly recall your names and your stand against this ill-advised, illogical, and totally unnecessary corporate profit-driven scheme to march across Coffin Butte Road in order to blast a hole into the side of Tampico Ridge, the home of sacred water. On behalf of my family, I want to thank you for your time this evening listening to our story. And I'd be happy to answer any questions that you might have. Thank you.
Thank you. Next up, we have Virginia Scott.
Good evening, Benton County Commissioners Weiss, Malone, Shepherd. Thank you for hearing my testimony. My name is Virginia Scott. My address is 37016 Soap Creek Road in Corvallis, Oregon. My credentials, I am a Soap Creek Valley Firewise co-chair. I studied fire with the Oregon State Fire Marshals, Oregon Department of Forestry, OSU Extension Service, Oregon Emergency Management, and the Insurance Institute for Business and Home Safety, and have witnessed a changing ecosystem. Tonight, you will hear from concerned, educated, and informed community members on subjects ranging from odor, noise, methane, PFAS, arsenic, leachate, traffic, air, water quality, litter, business impacts, livability, wildlife emergency services, health, and fire, among others. I urge you to ensure that all of these voices are heard as they share their insights on this monumental decision. I am a cancer survivor so far. I am not on the cancer map that you received in your written testimony, illustrating cancer clusters in our valley. Is my cancer the result of toxic air or water, or toxins that I may have been exposed to secondhand from a household member who served as an Adair Rural Fire and Rescue volunteer and who responded to multiple landfill fires each week back in the 90s, including the big 1999 fire? Did he bring home toxins from the landfill fire smoke on his clothes, skin, or vehicle? We don't know, because neither the county nor the state have studied our local cancer cluster. I urge you to consider the written testimony that addresses this phenomena. This evening, I am focusing on the fire risk from the landfill. After planning commissioners unanimously denied the expansion, Republic Service made an information request to the Adair Rural Fire Department. It was very limited. They asked the fire department for fire department response to only the working face of the landfill. They said, don't look over here at the flares. Don't look at the PRC. Don't look at anything except the working face of the landfill. As a result, they got a limited view of the fires and the fire calls to the property and the surrounding area. Of course, they are no longer comparing apples to apples. They are now comparing a slice of an orange to an apple. During the September 10th, 2025 DSAC meeting, Paul Koster from Republic Services, after receiving these limited results, made a cavalier comment about just one fire per year, to which I would reply, the Alameda fire, which was also just one fire, killed at least 11 people, burned more than 1.1 million acres of land, and destroyed thousands of homes. If our one fire happens during a red flag event, we could be next. Per BC 53.2151, that would seriously interfere with adjacent properties and the character of the area. I see that the staff is proposing conditions of approval that require Republic Services to implement after-hours monitoring and sensors and provide after-hours staff on red flag days. During the same September DSAC meeting, Mr. Coster stated that Republic Services would not be making those implementations. This is refreshingly direct for Republic, a company that has said that they would not comply, that they would comply with COAs and then didn't. We have Mr. Coster's statement at the DSAC that they will not comply. Remember that approving the CUP with conditions of approval is exactly the same as approving it without conditions of approval because they are never enforced and never met. Republic has proposed providing the county with $80,000 a year to pay for a compliance monitor. $80,000 would not pay for an FTE administrative assistant with standard benefits, let alone the multiple scientists and specialists needed to monitor compliance. And monitoring is not the same as enforcing compliance, especially if enforcement requires going to court. Surely, an out-of-state corporation with a market capitalization of $69 billion could provide after-hours monitoring, sensors, and staffing on red flag days now, not contingent on an expansion. But instead of addressing the issues exposed during the Planning Commission hearings, Republic Services Valley Landfills has spent their capital on PR campaigns promoting false information cloaked as a grassroots community movement. Again, after the September DSAC meeting, Mr. Coster assured the committee that Republic Services applies daily cover to the entire working face nightly and has staffs photograph it. In my written testimony, I show several examples of non-existent or partial daily cover. A landfill with exposed garbage and explosive levels of methane is an ignition source, either from within, such as from lightning strike, some undetected hot content like lithium battery, or from external sources like a windblown ember from a nearby fire. With a landfill fire, even if it does not escape the landfill, neighbors may be evacuated due to toxic smoke, and volunteer firefighters will be exposed to it too, and take it home to their families on their clothes, skin, and vehicles. Another undue burden on services. Paul Coster seemed to suggest that he did not know the definition of red flag days here in Oregon. For the purposes of this CUP appeal consideration, the staff considers Republic Services to be an expert. As a mere Firewise co-chair and local resident, I know when a red flag day is coming and when it is in effect. How do I know? My weather site, my local radio station, my text alerts from the state, my watch duty app, and local fire department status boards all tell me when a red flag day, we are in red flag day conditions. Mr. Coster seems to expect a Dare Fire to personally notify him. This seems like an undue burden on our services. The staff also proposed a condition of approval that Republic report all fires, regardless of size, to DSAC and to ODEQ. Why is a COA being proposed for an already proposed that is already a requirement on page 11 of the 2020 ODEQ solid waste disposal site permit? My written testimony shows that in spite of this existing ODEQ reporting requirement, Republic has only reported 2 of their fires to ODEQ since January 1st of 2020. Both of these reports are sparse, inaccurate email notes about the circumstances that do not include steps for preventing future repeats. Commissioners, you do not require violations of the DEQ, EPA, OSHA agencies regulations to be adjudicated before using those to weigh your decision. You can use your own judgment. The list of inaccuracies, misstatements, and underreporting goes on and on. Mr. Coster and Mr. Walsh say that the new enclosed flare cannot cause a fire as it has no exposed flame. But the heat signal from the enclosed flare is visible from space. I have referenced a video provided in the record showing flame and black smoke shooting out of the top of the enclosed flare. As any local resident knows, hay devils could easily sweep hay or trash through the flares to ignite and then light surrounding brush on fire. Mr. Walsh tells us that a small grass fire at the landfill is not a risk to the community. On September 27th, a grass fire near the landfill at Granger and Pettibone spread quickly into the grounds and torched in nearby trees. More than 20 households had to respond to a level 3 go now evacuation. The fire required 5 counties to respond and extinguish it. We have been given, had we been having a wind event during the last flare fire or PRC fire, those one fires could have been very different outcomes. Thank you.
Thank you. And before we move on to the more testimony, it is 10 o'clock. I just wanted to check in with staff on how much time Maya Abels, Peg Herring, and Jeffrey Kleinman had been allotted. Okay, so commissioners, they have been allotted 6, 10, and 22. Do we want to try to hear 1 or 2 more, or do we want to just move till a couple more?
So you said 6, 10 minutes and 22 minutes?
Yes, I'm inclined to push the 22 minutes till tomorrow.
I would agree with that.
Okay,
if that's
so
all
in
right.
that case, my apologies to Jeffrey Kleinman. We will take your testimony first thing tomorrow, but we will proceed with Maya Abels and Peg Herring.
Good evening. My name is Maya Abels. I live at 5888 Southwest Grand Oaks Avenue in Corvallis. And I'm a 40-year resident of Corvallis, and Grand Oaks is in the southwest part of the city. And I want to say, I really appreciate my weekly garbage service, but that's not the point. As a 40-year resident of Corvallis who really loves living here, I'm gravely concerned that this proposed landfill expansion, if it's approved, will change the character of Corvallis and Benton County. When I first moved here, Coffin Butte was a small county-owned dump. Today, it's the 2nd largest landfill in Oregon, now privately owned and operated by the 2nd largest waste management company in the nation, Republic Services. And last year, Republic Services generated over $2 billion in net income, mainly from garbage collection. And when you collect that much garbage, you need a place to dump it. Republic has found the perfect place to dump its garbage, Benton County, the county you represent. Yet Benton County garbage only makes up 7% of what goes into the Coffin Butte landfill. Republic Services hauls in more than 1 million tons of garbage each year from 2 states and 22 counties and dumps it all in Coffin Butte in Benton County. Again, 7% of that comes from Benton County. So to expand this landfill, which is a priority for Republic Services, that really gives all these other counties and municipalities an opportunity not to have garbage to have to worry about. It's out of sight, out of mind, and it's dumped in Benton County. And what do we get in return for such generosity? It's a good question. For years, I've enjoyed hiking in Mac Forest near Coffin Butte and riding my bicycle on Independence Highway. But it's changed. I often experience the putrid smell of the air and I see trash spewed on the roadsides from all the truck traffic. And not surprising, since the garbage trucks from these 22 counties and 2 states deliver garbage every 78 seconds. And all of that traffic and the garbage and the air makes bicycling and hiking really unpleasant and unhealthy. And if the dump expands, this is only going to be increased. The landfill odor and traffic are just the obvious effects from this gigantic mountain of garbage. But there's more. Satellite images show some of the largest methane plumes in the Pacific Northwest emanating from North Benton County. And in 2022 and 2024, the Environmental Protection Agency found multiple methane leaks at Coffin Butte, some at explosive concentrations. This dangerous climate heating pollution will worsen if the dump expands. Coffin Butte trucks about 40 million gallons of toxic leachate every year to waste treatment plants. And these waste treatment plants have no capacity or technology to properly clean that leachate. So 40 million gallons of water contaminated with solvents, PFAS, and other toxins pour into the Willamette River, where I like to kayak. And it also goes a few miles upstream from the Adair Village water supply. This poisonous problem of leachates is only going to expand if the dump expands. Now, Benton County's Planning Department has listed multiple conditions related to Republic's conditional use permit request. But the county now will get some funding to monitor these conditions. But really, is it going to be enough? And what kind of jurisdiction will there be to oversee the remediation to prevent violations? As you commissioners consider this expansion, these conditions should raise a lot of red flags against this dangerous expansion. Why should Benton County residents have any confidence that Republic is going to address these conditions? In the past, the county has never been able to follow up on violations, and we have no documentation that these conditions have ever been addressed. Now, the restrictions set by the legal counsel are designed to force you, our county commissioners, to see, hear, and consider only the narrowest possible line of inquiry and to ignore overwhelming evidence presented during the Planning Commission's hearings. These restrictions serve Republic services only and not Benton County residents, but it doesn't have to be this way. Benton County prides itself on its livability. The county website touts its long history to secure healthy, prosperous communities now and for our future. Republic Services is contractually obligated to continue to take our trash until the year 2040. It's not going to close tomorrow if the expansion isn't approved. That gives us 15 years to implement a truly environmentally clean and
Thank
strong
you. Your
solid
time
waste
has come to an
management
end.
process.
Thank you so much.
Okay, thank you.
And last but not least, we have Peg Herring.
My name is Peg Herring. I live at 34386 Colorado Lake Drive, Corvallis. Commissioners, thank you for being here and for listening and thinking about this big decision. I've been a resident of Benton County for 35 years. I'm an emerita professor at OSU and a member of the Great Old Broads for Wilderness. And before you chuckle at our funny name, you should know that we are a national organization of retired professionals who work toward the protection of American landscapes. More than 100 of our members are residents in Benton County, and we care deeply about the environment of the Mid-Willamette Valley. Earlier this year, we witnessed the Planning Commission hearings, and we learned a lot. We learned that Republic Services is under contract to continue to take Benton County trash for another 15 years. Despite what we've been told, the dump will not be closing anytime soon. We learned that plumes of methane spewing from Coffin Butte are visible from space, but apparently few are detected by Republic's own monitoring. And we learned that 93% of the garbage forming that methane is from more than 20 counties outside of Benton, all of them more than happy to offload their garbage and their responsibilities to Benton County. And now Republic Services says they need to expand to bring in even more. What we didn't learn from the earlier hearings is why on earth would the Benton County government agree to this expansion? Is it the money? Well, we're not allowed to talk about the money, but the people of Benton County have been deceived. There are pages of testimony in the record that analyze the $1 million a year incentive that Republic Services has paid to gain this expansion. However, we learned that Republic is contractually required to pay Benton County at least $2.5 million a year until the year 2040 without an expansion. So, is it the lack of alternatives for our garbage? Well, there are a lot of economical and environmental alternatives, but we're not allowed to talk about them. And with that, the people of Benton County and our neighboring counties have been deceived. Again, there are pages of testimony on the record that outline good available alternatives for this expansion. This includes work from the county commissioned work group called Benton County Talks Trash. And they've outlined a path to sustainable waste management for the Mid-Willamette Valley. So we have good, affordable options on the table and 15 years to implement them as alternatives for everyone. So why are we talking about expanding this problem instead of solving it? Perhaps it's because the county's legal advisors have allowed you, the Benton County Commissioners, not to consider past decisions or future consequences or the methane spewing from the dump or the toxic leachate poured into the river or the money promised or implied or anything about real alternatives to an ever expanding regional landfill. But the limitations that are imposed on your ability to think through this decision are arbitrary and they ignore relevant content. Within the narrow limitations of this hearing, we are allowed to talk about serious interference with uses on adjacent property. And again, we heard heartbreaking testimonies of neighbors' properties sold at fire sale prices because they could no longer function as farms or businesses or homes without having breathable air or drinkable water. There'll be more stories like that if the landfill expands, but we can't talk about that. We are allowed to talk about serious interference with the character of the area, and we heard hours of testimony about the offensive sight, smell, noise, and pollution from this landfill. These problems will get bigger if the landfill gets bigger, but we can't talk about that. We are allowed to talk about the undue burden on public services and facilities. And again, we heard powerful testimonies, including the Adair Village Volunteer Fire Department describing the dangers they face when they're called to fight potentially explosive methane-fueled dump fires. But whether or not the planning staff like it or not, we've got to talk about the undue burden on the people of Benton County. Planning Committee Chair Nicholas Fowler asked the pointed question, when state and federal agencies responsible for environmental monitoring are not living up to those responsibilities, doesn't that put an undue burden on county government? And when county government is unable to monitor or enforce these conditions, doesn't that put an undue burden on county residents? And when county staff advise commissioners to dismiss credible evidence collected by those county residents, doesn't that put an undue burden on these hearings to fairly consider all the facts at hand? The relevant context in this case is an expanding source of toxic pollution that reaches far beyond what we can see or smell on adjacent property. An even bigger landfill will bring even bigger problems. So whatever short-term windfall of money the county thinks it might receive from this deal will not cover the enormous and undue burden the residents of Benton County face now and will face later when this landfill eventually closes and requires an expensive environmental cleanup. We've witnessed 50 years of incremental decisions by Benton County government about expanding Coffin Butte. Individual decisions that must have seemed small at the time, almost inconsequential, but cumulatively, those decisions have added up to an environmental mess that no one planned and no one wants. But here we are. So please, Commissioner Malone, Commissioner Shepherd, and Chair Wise, you are the last commissioners who will have the power to end this long history of bad decisions. Please deny this expansion and save Benton County. I cede any additional time I have to tomorrow's talks.
Thank you. Thank you very much, everyone, for coming today and participating. We are at the end of our time. We will continue this hearing to tomorrow at 5:30 here at the Fairgrounds Arena.